privacy policy, you can find these on the DPA website. So first of all, thank you to my colleague David for facilitating today's meeting. He is just hiding in the background and will step in if there's any technical issues this morning. Hopefully there won't be any. So the appeal is by Edinburgh Marina Holdings Limited against the City of Edinburgh Council's decision to refuse its application under Section 42 of the Town and Country Planning Scotland Act 1997, seeking to implement plan permission previously granted on appeal, and that was referenced PPA-230-2458-1, without complying with conditions 1A and 1B of that permission. And in short, those conditions require the submission of reserved matters and the commencement of development by 20th June 2023. The applicant was seeking to extend this period by 3 years to 20th June 2026, but given the passage of time since that application was submitted, the party is now suggesting the period is 3 years or 20th June 2028. The appeal was previously considered by one of my colleagues, and a decision dismissing it was issued on the 13th of June 2024. However, this was appealed to the Court of Session and was subsequently quashed. The matter was then remitted back to Scottish Ministers for redetermination, and I have been appointed by the Scottish Minister to undertake that. So this hearing session this morning will cover conditions and the need for contributions and how these should be secured if I'm minded to grant the appeal. And the reason I'm considering this is that if I do grant the appeal, or I'm minded to grant the appeal, then what would be issued would be a new plan permission in principle, and that's why these are important to consider. An agenda has been issued already, and hopefully you've already got that. So first of all, for the benefit of the broadcast and for those who weren't here yesterday, can lead participant for each party introduce yourselves and those participating on your behalf? So if I start with the appellant first, please.
Good morning, ma'am. My name's Graham Dunlop. I'm a member of the Scottish Bar, and I'm here for this hearing 3 session representing the appellant. We've not got a large screen, but I'm in a room with certain people who I think may have been in the hearing yesterday. I'm in a room with Steve McGavin, who will also be giving evidence or assisting the hearing this morning with myself. There are a number of other people. There's Mary Swanson, a solicitor with Turk and Connell. There's Gary Freckleton, who's a qualified architect, who I think you may have heard from yesterday. And there's Katie Pearson, who's a senior planner at WSP. They're all in the room with me. Remotely is Mr. Charles Price, and I think you also heard from him yesterday, and I'm not expecting anyone else from the appellants. But as I said, I'm hoping that it will only simply be myself talking this morning, and also Mr. McGavin.
May I add that Arrow are also present, Madam. So if they want to introduce themselves, but they are there. That's Martin Williams and Steve Shakespeare, who saw yesterday.
Yes, okay, that's no problem. Okay, thank you, Mr. Dunlop, that's really helpful.
Sorry, Graham, they're shown as London Boardroom 01, that's why you didn't pick them up, okay.
Thank you, Mr. Price.
But they were on the hearing session yesterday, so I know who they are, which is helpful. And for the council, Mr. Nelson.
Good morning, ma'am. So I've got Graham Nelson, solicitor for the council, and closest to you is Kenny Bowes, who's senior planner. We then have Chris Sillick, who's a planning officer, planning officer in this case. And then we have Naomi Sandilands, who is another senior planner. We'll speak on various Section 75 matters today. And then to my left, there is Elaine Watson, who is learning estate planning officer.
Thank you. And we've got Mr. Gibbons here this morning too. Now, the reason for Mr. Gibbons taking part is that we didn't actually cover yesterday's part of the flooding hearing session, a discussion on the flood defence planning obligation that the council are looking for. So I invited Mr. Gibbons to come back today to be part of that discussion, because that's what he's interested in. That was what his objection is about. So, Mr. Gibbons, do you want to introduce yourself to everyone here today?
Yes, thank you, ma'am. My name is Lester Gibbons. I'm an owner and resident here at Granton Harbour, and I have been since 2013.
Thank you, Mr. Gibbons. So just a few housekeeping points just before we start. When you're not speaking, if you can maybe ensure your microphone is muted, generally in case there's any feedback. There wasn't a big issue yesterday, it's just to cut down background noise or feedback. If you need to contact others in your team who are not in the same room, that's fine, but make sure your phone or device is on silent. And if any team, particularly if the appellant, needs a break or short adjournment to discuss any point, then please let me know and we can facilitate that. That's no problem. Depending on how we progress, we may have a short break during the morning, but we'll do that at a convenient point in the evidence. So for those who maybe haven't taken part in a hearing session, the format is a structured discussion between the parties, chaired and guided by me. And the purpose is to allow all parties to put their views forward and at the same time to allow me to obtain the information I need to determine the appeal. The discussion should focus on the issues identified in the agenda, and relevant questions of the party can be asked through me. And as we found yesterday, that did work quite well and we did get into more of a discussion. Remember that I am taking notes, so please speak slowly one at a time. If I don't get something, I may ask you to repeat it. I know it is being recorded, but it does allow me to maybe think and just jot down pertinent notes that I want to remember going forward. So before we move on to the substantive part of the hearing, are there any procedural matters or questions any party has at this point in time? Mr. Dunlop, I'll come to you first with the appellant.
Sorry, ma'am, I was just simply unmuting on my colleague's computer. No, there's nothing for the appellants, thank you.
Okay, thank you. Mr. Nelson?
No, ma'am, nothing for the council.
Okay, and Mr. Gibbons, any questions or want to raise at this point?
No, thank you, ma'am.
Okay, great. Okay, so before we launch into the questions on the agenda, I have got certain documents to hand just so I can get access to them very quickly. So I've pulled up the previous Section 75 agreement, the ownership plan that the appellant produced a couple of days ago, the council supplementary guidance, the council's response on education infrastructure, which was document 54, and I've got the city plan and MPF 4, and I've actually got the previous decision notice 2, which was document 24. Are there any of the documents that would be useful for me to pull up and have to hand at the moment? This doesn't preclude you taking me to any other document I may have in the system, but it would just be easier if you want me to pull anything up now. So, appellant, is there anything, Mr. Dunlop, is there anything you want me to pull up just now, or do you think I've got the key things?
I may refer briefly to the decision by Mrs. Cook dated the 13th of June 2024, and I may also refer to Circular 3 2012, Planning Obligations and Good Neighbour Agreements, but those are the only documents that I anticipate referring to, other than obviously the Section 75 agreement.
Okay, I've got that decision. Yep, that's fine.
Yeah.
And I'm probably familiar with Circular. Okay, that's great. Mr. Nelson?
I think collectively between what's been referred to between you just now, that should cover what documents we need to refer to.
And Mr. Gibbons, is there anything you'd like me to have to hand?
No, thank you.
Great. And I'd say that doesn't preclude anyone going to any other document that has been submitted as part of the appeal. They're all before me, they're all part of the evidence. So let's start with question A, and we'll work through the agenda. We may stray into other questions. We had this yesterday where some questions were covered in a bigger discussion. That's absolutely fine. I will take stock as we go through to make sure I've covered everything I want to cover. I'll just let the discussion kind of naturally develop if possible. Okay, so question A. And this is, would the existing Section 75 agreement apply to the plan permission that would be granted if the appeal was allowed, given the terms of the agreement and the terms of the Court of Session judgment in the City of Edinburgh Council against Scottish Ministers and Granton Central Developments Limited and Lester Gibbons? So I'll seek views from the appellant and then the council on this one.
Thank you, ma'am. I suppose I may take about 5 or 10 minutes going through this. My apologies in advance. I suppose what I first should do is set out what happens, or what I say happens, when there is a Section 42 application and there has been a previous consent, obviously, with a Section 75 agreement. There's no automatic transfer, if you like, of the Section 75, and equally, there's no automatic non-transfer of the Section 75 Each case depends on its own circumstances. What you're required to do, and the test is set out in an authority, it's Norfolk Homes Limited against North Norfolk District Council, which is reported at 2020 EWHC 2265, and it's a Queen's Bench decision. It's a decision that's been followed since 2020. It's not yet been applied in any reported Scottish cases, but ma'am, as you will know, the provisions of section 42.2 are identical to the provisions in England under the 1990 Act in terms of section 73.2. And what you're required to do is you're required to look at the particular section 75 agreement and ask the question, is this section 75 agreement only tied to the original consent, or is it tied to the development that was envisaged under that consent? And that requires essentially an interpretation or an analysis of the particular section 75 agreement. And if the section 75 agreement says all these obligations arise out of, are due to 2000, the previous permission, then it's unlikely to transfer. Whereas if the section 75 agreement says you require to, there's various obligations and you're required to do these because of the development under that earlier consent, then it does transfer. So unfortunately, there's no yes or no answer. It depends on the particular document, and I suppose that keeps lawyers busy. Now, if we were to look at the particular document, the section 75 that we have before us in this case, the particular passages or the particular clauses that I would take you to, ma'am, are firstly the definition of development site, which is on page 4 of the agreement. And I perhaps can, I'm conscious everyone's noting, or at least you're noting, ma'am, I can perhaps read a little bit more quickly if I'm referring to a passage in the document. So it tells us that the development site means the area of land belonging to fourth title, which is registered as at the date hereof in the Land Register of Scotland under title number MID 29481 as at the date of this agreement, extending to 33 hectares, are thereby situated at Granton Harbour, Leith, Edinburgh, and which is shown delineated in red on drawing 1, and which is part and portion of all and whole that area comprising parkland and water lying to the north of Granton Square, Edinburgh, in the county of Midlothian, and forming part of Leith Docks, Edinburgh, described and shown delineated, outlined in red on the plan mark, plan number 1, annexed and subscribed as relative to notice of title in favour Forth Ports plc, dated and recorded in the division of the General Register of Saisons for the county of Midlothian and at the date. So what we have here is a definition of the development site without any reference to the earlier consent. And if we then look at what the obligations under the agreement require, in my submission, what they do is link it to the development site and are not, strictly speaking, required in terms of the earlier consent. So what I'm saying is that essentially the section, I suppose I should say what my submission is before I look at particular passages. What I say is that the section 75 agreement is dealing with the development rather than the particular consent. I appreciate it arises out of the consent because it wouldn't have occurred any other way. But what I say is that properly interpreted, the section 75 agreement is dealing with obligations concerned with development of the land rather than the particular consent. The original consent is development of the land in accordance with what that consent was granted for, but it's not restricted to the earlier consent. And the reason I say that, and I'll maybe just look at a few of the passages within the conditions and clauses within the agreement. As we go through the agreement, we'll see that there's very little reference to the consent. What there's reference to is the development site, and that essentially is scattered throughout. It's all references to the development site, which of course has no reference to the earlier consent. So, for instance, on page 8, see residential plots means areas of land forming part of the development site. Again, there's on that page, no reference to the consent. On the next page, no reference to the consent, but there are references to the development site. We see that under strategic travel plan. Turn the next page to page 10, we see total affordable housing units. We see the definition of that means the lesser of 510 residential units, and the number of which is 15%, all residential units to be constructed on the development site. So that the units themselves make no reference to the consent, it's just simply the development site. Go through, if we look at paragraph, the first one, affordable housing at 2.1, Forth will allocate 6 areas on the development site. So these are the obligations under the agreement, that Forth will allocate 6 areas on the development site for the development of affordable housing. Such areas will be nominated, blah, blah, blah. No reference to the consent. We turn the page to 3.1, the next obligation. Infrastructure contributions, subject to clauses 3.2 to 3.6 here, all Forth shall be bound to procure in each sale the residential plot within the development site that the housing developers purchasing will pay educational contributions to the council, and so on. No reference to the consent. And as we go through, we see that essentially the references are all to the development site. The obligations arise from the development site. Now, of course, the section 42 doesn't change the development site. Section 42 is concerned with conditions. So the development site is remaining static through the previous section 42 application and the present appeal that's before you. If we, again, I'm just not picking them in any particular order. On page 18, we see paragraph 7.1. And I think this is one of the improvements to Granton Square, which understands one of the issues in the current heads of term being tabled by the council, that the council requires that the road layout arrangement at Granton Square should be improved following the grant of consent on account of the anticipated increase in traffic flows arising out of development to be undertaken on the development site and other neighbouring developments. Forth have agreed that they will contribute to this requirement by undertaking to procure the appropriate road alignment works are completed free from cost to the council in accordance with the terms of this clause 7. Similarly, if we looked at, I think the Western Breakwater was discussed, or certainly flood issues were discussed yesterday. If we look at page 22, paragraph 11, it states that in terms of the Western Breakwater obligation, Forth will procure that the structure of the Western Breakwater forming the western boundary of the development site will be incorporated as part of the common parts of the development site following the development, in order that its future maintenance will form the obligation of proprietors of the site, and in particular to ensure that no liability for future maintenance of the Western Breakwater will accrue to the council or its successors as Coast Protection Authority. So what I say is essentially, I just pluck these ones out essentially, not at random because I've highlighted them, but not in any particular, for any reason other than to demonstrate that what the Section 75 agreement was concerned was with the development of the site. Now, granted, as I said, that is in accordance with what was granted permission for originally, but there's no reason that cannot transfer. The Norfolk Homes case demonstrates that. I think paragraphs 90 to about 95 are probably the relevant ones. I appreciate that document's not before you. My apologies for that. I've only recently been instructed, really only this week. So, but I do appreciate there wasn't any authorities, as far as I'm aware, exchanged. But I'm sure if it's something that the council require to come back on, I'm conscious that in other similar situations, the reporters have afforded people an opportunity to come back and comment on a case if necessary. So I apologise, and well, maybe not in advance, but during my submission, for it not being before the council or yourself. In terms of there's a clause clause 16 is basically the only clause which, and it may be the clause that the council wish to draw your attention to, but clause 16 is the relationship to the consent. But I say that clause 16 is of not no effect, but is of no concern in terms of the submission I'm making, because it says this agreement shall not have effect in the event that the consent is revoked or the consent is not implemented. And in my submission, that hasn't applied. It hasn't been revoked, and there has been implementation of the original consent insofar as there's been work carried out. The next point, just I suppose just dealing with the agreement. The agreement doesn't state that it ceases to have effect in the event of a Section 42 application. If that's something that the parties had intended, then that could have been incorporated. I've also noted that in the earlier decision of the reporter dated the 13th of June 2024, this is at paragraph 9, and I don't think this is binding on you, but there's reference and discussion to the Section 75 agreement. And in that decision, so that's the decision by Ms. Cook dated the 13th of June 2024, at paragraph 9, in the last sentence, with discussion regarding the Section 75 agreement, it says that the council and the appellant confirm some but not all of the requirements have been performed. Now, it doesn't tell us an awful lot, but the little it does tell us is that as at 2024, both the council and the appellant were still discussing the obligations, the planning obligations under the Section 75 agreement. What we also have is the decision of the Inner House, which is referred to both in the reporter's decision I just referred to, and I think the decision of the Inner House is before this appeal. But the court found that the Section 75 was relevant to the new permission. Now, of course, the court didn't go into an analysis of the interpretation of the Section 75 agreement. I just highlight that the court was of the opinion in 2020 that it was relevant to the new permission. So there was no suggestion that it should just be, I think I said at the outset that there's no automatic, oh, it's a Section 42, that's the original Section 75 agreement or the existing Section 75 agreement torn up. It's a question of interpreting whether or not it relates to the development work that's going to be required to be carried out on the site, or whether it just is solely in relation to the consent. And in my submission, the way it's been drafted in such a way as it will apply to the development site and the works to that site, rather than simply the consent, the original consent. I think that probably deals with the point that I was going to make in relation to the question A. I don't know, unless I can be of any further assistance. I mean, there's obviously related questions coming under B, but I think the question A is, would the existing Section 75 agreement apply to the planning permission? My position is yes, it would, for the reasons that we've discussed. So unless I can be of any further assistance, that's the appellant's position on Council A. And I maybe just, when I say that's the appellant's position, I should maybe just wait to make sure that Mr. McGavin's got nothing further to say. And unless anyone else will get anything further to say, no, that's the appellant's position on A. Thank you for your time, ma'am.
No, thank you, that's really helpful. I have a couple of follow-up questions, but I'll let the council come in with their views first. Mr. Nelson, I know you've probably just been aware of that court case that Mr. Dunlop cited. Do you need any time to consider that, or are you happy just to give me your views?
I think it would probably be helpful to have time to consider that further, ma'am. I'm happy to give you my preliminary views on the rest of it, though, because I think it doesn't change probably what most of our views are in terms of it. I think, firstly, I would agree that depending on how the Section 75 agreement has been formulated, that potentially it can continue to apply on a Section 42 under explanation. I don't believe that to be the case here. If the Section 75 agreement had expressly had reference to the consent and said that it also applied to non-material variations in the future Section 42s and had an express provision to continue to apply it, then certainly there would be a clearer legal argument to be saying that it continues to apply. That's not the case here. The start of the Section 75 preliminary paragraph B makes clear reference to what consent Section 75 relates to. Consent is clearly defined in Section 75 as only 01/00802 out. You can clearly have multiple applications and multiple consents on the same site and different Section 75 relating to them. So the key elements of that is what is planning permission, what is the consent. And the only consent that the 75 is referenced to and linked to is the 01 consent. It's not linked to anything else. I acknowledge what the references to the agreement to the development site, that may well be the case. I'm not disputing that there's reference to the development site in an appropriate manner to give interpretation to such clauses. That doesn't change the underlying position of what consent does this Section 75 relate to, and that is the 01 consent. Now, turning to the court's decision, the court recognised the reporter's intention with the 2019 decision by the reporter to continue to comply that Section 75 to the new consent. That's not disputed. What the court then went on to say was, if there is an issue about the continued application of the interpretation of the existing Section 75 agreement, continued application or the interpretation of the existing 75 agreement, that can be resolved in due course. So the court recognised this is problematic in terms of does it continue to apply or not, in terms of is it a clear link and title that relates it to the newly created consent with a new consent number. But I reckon that could be resolved in due course. Now, I think we took that at the time, meaning that if you were creating AMCs, then at that point you could have a linking 75 created for each AMC that linked it back to the old 75. So there was a clear link and title that you clearly linked it to those consents. But that was the only sort of workaround to what was left with not having this 2003 75 linked to the new consent. I think otherwise, just point briefly this, the circular. That's fine, remind me, circular of Annex H of.
Annex H of Circular 3/2022, Development Management Procedures.
And that's in relation to Section 42 applications on this annex that gives guidance on that. And it's quite clear about the importance of continuing to not just apply the new conditions to the new consent created by Section 42, but also of applying any new 75 or continuing to apply the Section 75 agreements to that new consent. So not just leaving it to what may or may not be in the title relative relative to an old consent, but it needing to be a new 75 that's clearly linked. I think that's probably our main submissions on this point, of why we consider it doesn't. It could, if the 75 had been framed differently, then potentially it could have done in terms of how it has been framed, that it clearly links just to the original consent, and it doesn't. It sits on the title, yes, it links to that consent alone, and not to future ones, and not to new consent that would be created by this permission.
Thank you. I've just got a couple of questions that I think for Mr. Dunlop, actually. And the first, it relates to that point from Mr. Nelson, and it relates to a specific consent. And I did wonder if you read the Section 5 in its entirety and took your understanding from it as an entire document, that by looking at the recitals at the start under recital 5 and 6, it's clear, or it does state in those paragraphs, what it relates to, which is that planning permission 01-008-02 OUT.
Yes, but I think the point, and I was going to ask if I could answer this, the point that was made by the council is that the only permission that is linked is the 2001 consent. There's no reference to any other consents. Well, yes, but that must always be the case with the first one. It can't possibly anticipate that there's going to be future ones. Now, in terms of, it would have been possible for them, I accept for it would have been possible for the drafters to say it includes any further Section 42 application, and that was considered in Norfolk Homes. But when you're interpreting the document, you're required to interpret the whole of a document. You can't simply look at a clause in isolation, and that's why I took you, ma'am, through various passages and said, essentially, when the document's read as a whole, what it's referring to is development of the site. It has to refer to the 2001. Otherwise, it would just be a kind of standalone agreement that would make no sense. But referring to the 2001 agreement within, as you identify recitals, I think 5 and 6, that doesn't detract from the fact that when you get into the body of the document, what it's essentially talking about is the development of the site. It's not, if it had said, you will provide 15% affordable housing in accordance with consent 01, then I'd have struggled to make the argument, but it's talking about development of the site rather than the consent. And I think, in fairness, I'm glad this is the case. I think the council and the appellant agree that it is a question of interpretation, and it's never black or white. It's a question, unfortunately for you, ma'am, to interpret the contract, hopefully with our assistance, and come to a conclusion one way or the other.
Does the definition of the consent in the Section 75 agreement make it clear that it's tied to a specific consent? Because that definition also has reference to the term development site in it. On page 3, if that helps you.
Yes, I have that. I mean, the consent is defined, and we have the development site defined. I'm sorry, ma'am, I'm not sure I understand the question. That's entirely my fault.
I maybe didn't phrase it very well, to be fair. So the consent refers to that plan permission in respect of the development site. So again, reading the agreement as a whole, would that make it very clear that it's the development site and the development under that permission?
Well, I think that's the point I make, that any Section 75 is always going to refer to development of the site. It's the fact that consent isn't littered throughout, that essentially what it's talking about, what the agreement is dealing with, is the development of the site. Because if you wouldn't have or I've certainly never seen a Section 75 agreement that doesn't refer to the consent. The fact that the consent says that it's in relation to the development of the site in itself, if that precluded a Section 75 agreement from having effect in a subsequent planning permission under Section 42, then it would never happen, because there's always going to be a reference to the consent in the context of the development. The question is whether, looking at the document as a whole, is it really talking about the development of the site, or is it really just talking about what the consent requires? I take on board the point you're making, but I think there always has to be a provision like that within a Section 75 agreement. I've certainly never seen one that doesn't refer to a consent or a planning permission. So I say no, it doesn't. It doesn't detract from the position that I was putting forward earlier this morning.
So just so I get in my head, so if one of the obligations had said, let me just pick one that you quoted earlier. So say, just go to 2.1 because that's the closest one. And he said Forth will allocate 6 areas on the development site for the development of affordable housing. So if that said for the development of affordable housing in accordance with the consent,
or only in accordance with the consent,
that would have tied it to, you're saying that would have tied it to that permission. It'd be very clear it was tied to that permission.
Yes.
Right. So taking that step further, given that that was an outline planning permission without any detail, could it have been tied to the consent, given that that detail is not in the consent?
Sorry, ma'am. I was reading something as you said that. That's entirely.
No,
my apologies. That was very rude of me, but I was just trying to see if there was a passage that helped me. But sorry, could you repeat the question?
So, I think we're saying that if it had said only in accordance with the consent, that would have clearly tied it to the original planning permission.
That would cause me difficulties, yes.
What I'm saying is that would it have been reasonable to have that kind of wording, given that it was an outline PPP? So all it was a red line. There's up to maximum numbers of housing, floor space, things like that in the conditions. But would it have been reasonable in the context of this document, which is actually providing some of the, I suppose, the meat on the bones and the detail, because the application was an outline PPP?
Well, but it could have been worded in such a way that, only in accordance with outline planning permission and any further applications made under that particular outline permission. It could have been drafted in such a way that it excluded Section 42 applications, or essentially excluded Section 42 applications.
Now, I've seen in some Section 75s that sometimes the consent is detailed as whatever the consent is, but includes any subsequent planning permissions. Again, if that would have been helpful, that would have made it clearer.
Yeah, that would have been helpful. I'd say it's not necessary, but yes, that would have been helpful.
But in the absence of that, could I take the view that this does just apply to that first consent?
No. I don't think that's determinative. It's determinative in a positive way, but it's not determinative in a negative way. So what I say is, if it said this Section 75 agreement applies to the 2001 consent and any Section 42 applications made under it or in pursuance of it, then I don't think we'd be having the argument at all. I think the council have accepted that if it said those words, then that would make it clear. I say that would be determinative, but the absence of the words does not make it determinative. Because what we have is silence in that. It doesn't exclude Section 42 applications.
And the last question I ask you, in relation to what the court said in the in-house case, the judge did say that if there's an issue about the continued application or interpretation, that can be resolved in due course.
Yes, I have to say that. Sorry.
And then they say it's matter stand, it remains relevant. Now, it's maybe the wording is just not very helpful, but by remaining relevant, does that mean it applies?
I don't think I can go as far as saying that. I think what the court have identified is that I think it is probably something the council and the appellants aren't disagreeing on. The court haven't said it does apply or it doesn't apply. What the court have said is it might apply, but that's a discussion for a later date. And I don't think the court decision takes us a great deal further forward than that. I think it identifies that it's not simply, you don't simply tear it up when there's a Section 42 application that's granted, but equally you don't automatically just go, oh well, it's a Section 42, the Section 75 agreement will apply. I think what the court are simply saying is that it's relevant. And the reason it is relevant in my submission is that because we're essentially dealing with the exact same development, just changing dates. I know we may get on to that later this morning, but and that makes sense, because why have a separate Section 75 or a fresh Section 75 when it's the exact same development and it's just a date that's being changed within the condition?
Other than, and we probably will come to, other than the policy content has changed dramatically since that outline plan permission was granted.
Yes, and Norfolk Homes recognises that you can look at material considerations, includes the position as at the date of considering the Section 73 in its case, but the Section 42 in our present case. So I accept that's something that you're entitled to look at.
And the council touched on, let's see what it was, the guidance on development management procedures, which I think is Circular 3, 2022. And actually, it was referred to in Ms. Cook's decision. If you have got that to hand,
yes, I have that.
It's the easiest place to look at it, and it's just paragraph 19. And I think she's paraphrasing from Annex H of that circular. She said, Annex H confirms that decision made under the section of the separate grant of plan permission that conditions from the previous permission should be applied were still relevant or required, that the need to secure a planning obligation to the new permission should be considered.
It can be considered. I suppose as we'll come on to that, that's probably point B, I think.
It probably is actually, yes.
Yeah, so I'm not going to say it can't be considered. It's how you deal with that. So it doesn't exclude, there's no question that it doesn't exclude you considering whether or not there should be I don't know if I would have used the word, what's the word used there? Yes, a new permission. Yes, a planning obligation to the new permission. Yeah, I don't take issue with those words. Sorry, I thought it would instead a new planning obligation, because obviously the Section 75 agreement, it's important to remember it's a contract. It's not been set aside. It's not been reduced. Simply because there's a new permission. If a new permission is granted, which is the procedure with a Section 42, you get fresh permission. If a fresh Section 75 agreement was entered into, that wouldn't essentially tear up the old Section 75 agreement. It would still exist.
Yeah. Okay.
Because I don't think the ministers have got the power to do that. It's a private contract between parties. It would have to be set aside or reduced by a competent court. So it still will exist. I know that I just noticed there's been some discussion about old and new Section 75s in some of the exchange of correspondence. Sorry, I think someone's got a relative that's in hospital, so sorry, the phone's been kept on. So yes, in short, I don't take any issue with that, or the way it's worded.
Sticking this to A, I'm going to drift into B. Sticking to question A, is there anything else you want to say in response to anything the council said? I'm going to go back to the council to ask if they've got any follow-up comments in light of our discussion, but is there anything else you would add at this stage that we haven't covered?
No, there's nothing further, thank you.
Mr. Nelson, do you want to make any further comments based on that discussion I've just had with Mr. Dunlop?
Only a couple of points, ma'am. I don't think it changes what I've already said on this. I agree with what your your submission and your suggestion that when you read the 75 as a whole and read what it states in references to the specific consent, that it clearly relates to that specific consent. Where I disagree with Mr. Dunlop is in terms of that the consent definition. It quite clearly doesn't have the provisions that you made reference to around non-material variations or future section 42 or any of that. Had it done so, then yes, if it was framed correctly, then it might continue to apply. It does not. And the section 75, it does just clearly relate to the 01 consent. The other point, I just maybe as an obvious point, but what was quite clear from this discussion is if it's left as being just this existing section 75, there's no debate from us that it remains in the title, doesn't cease to exist just because new consents are granted. That's true. But if it's left as just that section 75, you're leaving it for a separate legal dispute, really, of does it continue to apply or not. There's clearly differing views of whether that legal agreement would attach to new consent or not. And our submission is that's not a position that we should end up in. This doesn't conform with the circular, and there should be a section 75 that does clearly relate to this consent. We've obviously made our submissions on that should be a new 75 with all the details, but equally we've also set out that if you don't agree with that you should still be directly applying the old section 75 terms to the new consent, so there's no dubiety.
Okay, then we can come on to that in question B. I think I understand both parties' positions. Mr. Dunlop, do you have any final comments on the part of the appellant?
Sorry, ma'am, I'm just unmuting my colleague's computer. No, thank you.
Okay, no, great. I think I've got enough on that. So if we can move on to question B. Now, I'm happy for you to cover all the bullet points in your submissions. That's absolutely fine. Or you can do it one at a time. I can go to the other parties. So, Mr. I'll actually ask the council for this first, since they are the ones who've requested the Section 75 agreement. So, Mr. Nelson, if you can deal with question B, please.
Yes, ma'am. So in terms of this, we think that's fairly straightforward in the first point, that yes, it is competent. It's obviously referred already to the circular in terms of the circular making reference to the importance of planning, not just planning additions to a new section 42, but any section 75 that is intended to apply. As far as the court decisions and the Granton court decision that we've referred to, it's certainly not making a submission that it would be unlawful or inappropriate to apply section new 75. All it was stating was it was not unlawful for that reporter in that decision to not do so and to choose to continue to apply the section 75. So I don't see there was any suggestion from any of the court cases that it's unlawful, and there certainly isn't from this section 75 statute in terms itself. As maybe touched on a little bit, then in our submission, the application, the original consent is 22 years old, and the development plan position has moved on considerably since then. Not least there being NPF4 now in place, which is a massive change in planning policy for Scotland, as well as the Council on City Plan 2030. In our submission, then this application and the creation of a new consent does need to be considered against the current development plan. If that's done, then a new section 75 that correlates to current development plan requirements in terms of developer contributions and infrastructure requirements is necessary. Indeed, I think it goes by as far as to say it would be pretty unreasonable to not apply that when those requirements would be being applied to any other new consent in the city. And this is obviously a considerable consent that yes, there's been a reasonably substantial amount of development over the years on the site, the best part of 900 houses, but the consent still allows for another 2,500 houses in terms of if new consent's created, so that the obligations to be secured or indeed lost if you don't apply new terms are considerable. I think that's the first point, ma'am. Do you wish me to keep going on to the next points just now, or do you wish to deal with them in turn?
I'm happy to cover all the points, and I'll go to Mr. Dunlop.
Thanks, ma'am. I think if it's in terms of being able to amend the existing section 75, if you're meaning that by varying section 75, then that's certainly open to you. I wasn't sure if you're meaning that or if you're meaning just to vary it to apply the new consent to that 75. That certainly is open to you, as we've already touched on in my last answer, in terms of I think something we've already submitted in terms of if you're don't consider it appropriate and reasonable to apply a new 75 with new terms, then it is appropriate, reasonable and necessary in terms of having certainty that the old 75 continues to apply to this new consent, would be to vary it with a reference to the new consent reference.
I was probably thinking of a bigger variation to this existing section 5 if I felt it was appropriate to change the contributions based on development plan policy. So I was probably thinking more in those terms as opposed to just varying it to make it clear if that was necessary to the new consent.
Thanks, ma'am, for that clarification. Yes, certainly the council and other applications will regularly look at whether variation or a new 75 is the best way to achieve those aims of setting out current obligations. I think there might be some hurdles with that in terms of the age of the 75 and aligning it with the new with current requirements of the development plans, just because things have changed quite so much over that passage of time. But it's certainly an option that's open to you in terms of varying the existing 75 rather than creating a new one. I think the next points maybe somewhat shorter of how would a revised agreement work when AMC applications have already been submitted. Then, yeah, our submission with that is that the existing AMCs are governed by either the original 2003 consent or the 2019 Section 42 consent, and what the court has said in that. I think we've touched on already with AMCs that if there was very limited AMCs under the or one AMC under the 2019 Section 42 consent, and relative to that, then we would have been looking at having a Section 75 variation or a new 75 just to directly apply the old 75 to that AMC, but we've not had a number of those to try and deal with. It's been very limited. But yes, it would continue to apply, the old obligations would continue to apply to those AMCs, and the Section 75 or the various 75 can be clearly framed to apply those new obligations only to the new consent that's been created and not have any retrospective effect to old and existing consents and AMCs. And I think that maybe partly covers point 4 as well, but we're certainly not intending that there's any retrospective effect.
Thank you. I think that does cover all the points. Mr. Dunlop.
Thank you, ma'am. I suppose what I should do is split, or first just identify that as a matter of general principle of law, it is competent for you to require a new Section 75 agreement to be entered into by parties. That's just as a general principle. Equally, as a general principle, it's competent to vary a Section 75 agreement. For the reasons that I'll go on, obviously, the appellant's primary position is that the Section 75 agreement is binding on any consent granted arising out of this appeal, the existing Section 75 agreement. And therefore, our primary position is that a Section 75 agreement is a fresh one, a new one, if you like, is not required, or a further one is not required. In terms of dealing with the particulars, could you vary this Section 75 that's before us at the moment? In my submission, it couldn't be varied. The difficulty with trying to vary it is that the terms of that Section 75 agreement have been incorporated into the title deeds of hundreds and hundreds of properties. I think over 800, I think the numbers are before you. I think there's approximately 800 residential units and maybe about 40 commercial units or thereabouts. So in my submission, it would be what you would essentially have if you tried to vary it is that you would have inconsistent obligations in different proprietors within different, because remember the Section 75 covers the whole site. So you would have essentially different components of the site with different obligations, and that, well, in my experience, that just leads to disputes, especially where there's different obligations in relation to maintenance obligations, and that's probably what would arise, because what the council are proposing is that it wouldn't have retrospective effect. So what you would have is you would have 800 residential proprietors who would be subject to what's in there now in their title deeds through a deed of conditions, which reflected what was in, call it Section 75 Agreement number 1. But then you would have other neighbouring proprietors, essentially, that were subject to different conditions in relation to the same maintenance and the same of the same common areas. It would be a conveyancing headache. So in my humble submission, it would be unwise. Is it legally competent? Yes, it's legally competent. I think the other there's
on that point before you carry on. I guess I totally understand your position on that, and I get the difficulty where it relates to maintenance obligations. I guess the same issue wouldn't arise in relation to contributions where those contributions had already been paid and discharged in respect of those properties.
Not the ones that were a monetary amount. What I will come on to say is that where you have, say it's a contribution for affordable housing, because the Section 75 covers the whole site, what we were working with the Section 75, because there only is one Section 75, the Section 75 requires a 15% contribution. Now, I understand that the council then sought, until about 2023, 25%, and then now that's up to 35%. Now, where that does cause a difficulty is that because the Section 75 covers the whole site, where part of the site has been essentially under the requirement of a 15% requirement, and we'll say that was half the site just to make things easy. I'm not saying it is half the site. You got half the site's got 800 properties. Let's call it 1,000 in half and 1,000 in the other, just to make the sums easy. Where you've got 15% requirement, and that's 150 properties. If the remainder of the site has to have essentially, if the whole site, the undeveloped proportion of the site has to have 35%, it's not just the undeveloped, it's the whole site that the Section 75. So what happens is you need to increase the percentage to 55 approximately to compensate the fact that the Section 75 says that the whole site will have 35% affordable housing. Given that, and I say half the site, I'm just using that for the calculation, if half the site's been built at 15%, then essentially to catch up for a whole site of 35%, that involves imposing a 55%, which there's no policy basis for doing so. So, sorry, that was a long-winded way of saying that there will be circumstances where it won't work just to simply say this doesn't have retrospective effect because the agreement covers the whole of the site. The other difficulty, of course, with the agreement covering the whole of the site is we're in a situation where it's only the appellants that are involved in this present appeal, and the appellants don't own the whole site. Now, we're not talking about conditions. With conditions, it can be competent to impose a condition where a party is required to do something in relation to third-party land which they don't have control of. Thing that's British Railways Board against Secretary of State for the Environment. But what we're dealing with here with a Section 75 agreement is we're dealing with a contract. And the problem is that if a contract can't be fulfilled, if it's impossible, then that frustrates the contract. And what we have here is various heads of terms being proposed by the council over land that the appellant just simply doesn't own. So to require the appellant to enter into an agreement for the whole site, it essentially is going to be, that will lead to a defective contract, and that will frustrate the contract, and it will be unenforceable. I mean, I think there was various, I wasn't obviously involved yesterday, but I think there was discussion about the flood defences and also various other things, but I hope it was, I'm turning around to my colleague, but I hope it was probably made clear that we don't own all the land that's the subject of the proposed Section 75 agreement.
We did discuss that yesterday in the context of one, the flood defence, and two, just the build out of the whole site. And we've looked at the phasing plan and we've looked at the ownership plan. So I'm well aware of what the appellant does own and the areas that it doesn't own. So yeah, we did cover that yesterday.
So I think that's a fundamental difficulty with trying to impose a contract, because that's what a Section 75 agreement is, a contract on a party that doesn't own the land. It'll automatically be impossible, which would frustrate the contract. And then you would be having discussions about whether it's a whole terms contract and so forth. But I'm not even getting into that. What I say is that you can't have a Section 75 which covers the whole of the site arising from this appeal.
Okay.
I have to say that I'm not sure. I mean, there's obviously one resident present, but I'm also not sure how that would affect the other residents. And I don't represent those other residents, but they might have issues in relation to any maintenance obligations that, as I said, if there was a change in the maintenance obligations, I could anticipate somebody, a resident or a group of residents saying, well, look, hang on, this is where our title deed say, well, there was an appeal and that changed what our maintenance liabilities are. I think that it just causes it's not just a headache. I'm just not sure whether it could be done lawfully, because you essentially would be affecting the titles of proprietors who are not here. Residential proprietors who may start making Article 8 noises, what about the right to my family home? To me, that's just not going to work. In terms of just the only other point I think that I have under this is that Circular 3 2012, in terms of the planning agreements, requires that planning obligation, the terms are reasonable, and that's measured by whether the obligations, it's paragraph 24 of the circular, and that's measured by whether the obligations are necessary for the development to go ahead. that they can't be necessary for the development to go ahead because the development was approved without what is being sought at the moment. Now, I appreciate that the council may argue, well, matters have changed, contributions should go up and so forth, but it goes beyond that. The heads of term go beyond simply updating numbers. They go beyond what's in terms of maintenance responsibilities. And at the time of granting the consent, there's nothing that's changed in relation to that. So it can't be said that they were necessary when it's already been determined that consent should be granted in accordance with the original permission.
But would you, if the level of putting the maintenance to one side, and I totally get your point on that, but think about contributions. If the level of contribution has gone up and is supported by development plan policy, would that justify an increase in those contributions? Would that be reasonable and necessary?
As always, I can't answer the question with a yes or no, sadly. It could, but what we say in this particular case is that we say that the council haven't justified. So in principle, looking at a Section 42 application, in principle, it's possible to say, well, you know, this is X number of years old, there's been changes since then. So in principle, it's possible to do it. What we say is, and I think we come on to education and transport contributions, and those will be dealt with by my colleague, Mr. McGavin. But what we say is that they're not linked to the development. But more importantly, they're not linked to any land that we own. Sorry, they're not linked, they're linked to the whole site, and we don't own the whole site.
Okay, no, I get it's difficult. I'm happy you give me an in-principle position, but I understand you will have a different view to go through the agenda. I totally get that. Mr. Price, do you want to come in for the appellant?
Yes, I just thought it might be informative, Madam, for you to know that the council have been requesting and indeed demanding a new Section 75 agreement. The first time it was brought to our attention was in March of 2016. And I think that's relevant. They wanted us to enter into, our clients to enter into a new Section 75 agreement. And the answer you've just heard, a response from council, was exactly what was said at the time. Maybe not in such a legal basis, but we pointed out that would be totally impractical. That at that time, the client did not own, the appellant did not own all the sites. Even by then, Forth Ports had sold off a number of sites before we came on the scene. And indeed, planning consent was granted for those sites, which comprised 26, 27, 28, 29, 30, 31, 3, 4, and 7A, which comes to approximately 900 flatted units. Upon the grant of that consent, under the Section 75 agreement that had been entered into with Forth Ports, those developers, as you heard yesterday, were obliged to pay a sum of money indexed to the date of consent. But that indexation we'll come on to for the school's contribution was subject to something. But the point I'm making is that this is long predates what's going on now. We pointed out then and repeatedly over the subsequent 7 or 8 years, and in a number of appeals which were found in favour of the appellant, it just was not an issue that was accepted by the reporters on each of these applications.
Okay, thank you. Mr. Dunlop, is there anything else you want to say in response to question B? Because I'm going to go back to the council.
I suppose I haven't dealt with the third bullet point, and the fourth really I don't need to deal with. The third bullet point, as I understand it, the appellants don't have any further approved AMSC applications to submit, so I'm not sure that really has any relevance to the to the appellants. Obviously, it has relevance to other, because the Section 75 it's proposed wouldn't apply to the whole site. It has relevance for other developers who own land, but I don't represent them, so I don't think I can really say anything in relation to bullet point 3, other than the fact that it doesn't affect us, but yeah, it will cause a headache for others that it will affect. Point 4 is dealt with the council, so I think, unless I'm just looking around my colleague Mr. McGavin just to see if there's anything under B that I've missed. No, I think that's all I have to say. Thank you.
Okay, thank you. Mr. Nelson, do you want to come back on any of those points?
Just briefly, Madam. So I think it's first point with this is just the option to pursue a Section 42 application for the entire site when they only own a limited amount is entirely a matter of the applicant's choosing. And I think it's highly questionable whether, when pursuing that path and creating a new consent through that should frustrate the application of the development plan and the application of applying a new 75 to considerable development. As I've already touched on, it's not a case that it's 50% developed, 50% still to develop. It's under 900 units and that have been developed, and there's still consent still allows for about 2,500. So the amount of development that's still to be captured by any new 75 is considerable, and the funding black hole in terms of developer contribution not being paid at current rates under the current development plan, it would leave a considerable gap in funding for all of that housing in terms of providing necessary infrastructure that's arising from this development. I think turning briefly to the affordable, sort of linked affordable housing issue that was brought up, and the council has already quite reasonably been stating with that yes, it's 35%, but taking account of all the affordable housing that's already been delivered on the site. And as I've just touched on with that, it's not a case that we've already had 50% and therefore we would be left with 55% affordable housing on the remainder. It's more like 25% of the site that's been delivered in terms of housing, and housing level. I think affordable housing levels and above the 50%. So the gap is far less in terms of what we need to be made up across the remainder of the site. And I think we've also set out that things can be phased in terms of the 35% requirement applying to each phase of development if that was a particular issue, ma'am, in terms of ensuring it's reasonable and that we're only applying the affordable housing contributions in terms of the development plan and not applying something that's over and above what the development plan requires. I might pass to my colleague Chris Sillick just to clarify some of that. I think he's got the details a bit more than me.
I can speak to some of the affordable housing numbers if it would be useful. I know we're going to discuss that at a later point potentially. It was just, and again, it might be that I misunderstood, but there seemed to be a suggestion that on the undeveloped element of the site, we would effectively be asking for 55% affordable housing. And apologies if I've misunderstood that, but if we look at the outline planning consent and its terms, in terms of housing, what it would give consent for is 3,396. Of that 3,396, 890 homes have been delivered, so effectively 26%. Of those 890, 546 are affordable. So if we were to apply a 35% affordable housing requirement to the 3,396 of the outline planning consent terms, that would result in a requirement of 1,188 approximately. So if we take 546 delivered affordable homes away from the 1,148, that leaves us with 642 to be delivered on the undeveloped part of the site. And as my colleague Graham's touched upon, there would still be potential for 2,506 homes to come forward on the undeveloped part of the site. So 642 out of 2,506 is approximately 25%, which would be under the 35% that we would ask for in the development plan for the undeveloped part of the site. Not 55%. But again, apologies if I've not followed that element of the discussion correctly.
No, I think you have followed the discussion. I think Mr. Dunlop was probably talking more hypothetically rather than absolute figures. But that's very helpful just to break that down for me. Mr. Dunlop, do you want to comment on any of that?
Yeah, simply to say that the way the heads of terms are drafted at the moment is that is 35% for the whole site. And I'm sure, sorry, I can't remember the name of the chap, and he lost me, but that's me. It was like a Carol Vorderman song in Countdown. I'm very impressive. I'm sure the numbers he's giving us is correct, but the problem is that when the heads of terms are drafted in a way that says you're going to have this percentage, then because there's been an older percentage that essentially that has diluted the whole site, then to me, the way the heads of terms are drafted, and it might not be the intention of the council, but the way the heads of terms are drafted, it essentially requires you to increase the percentage beyond policy percentages to compensate for a lower, the 15% that's currently in place. And I think that applies regardless of any number crunching. It's because what we're looking at is what the Section 75 says and what the proposed heads of terms say. I think looking at those together effectively will require, because they both apply to the whole site, essentially what's gone before has diluted the objective or the goal of the council. So I think it still does apply. I don't know if Mr. Price has got his hand up or not. Maybe not taken off from the last time, but
no, I do have my hand up because it may assist you. First of all, Mr. Sillick's numbers seem to forget one very fundamental point. There have been master plan approvals. The first of those, the most relevant one, was given on the 31st of January 2014. I know about it because it was a condition of the purchase from Forth Ports. So before completion took place, an application was made to reduce the overall number of flatted units for economic purposes because it's made up ground and the amount of car parking and basement space was uneconomical. So the current figure that he should be referring to is a total of just under 1,975 units. That's what the master plan consent is for. He will also interject, I'm sure, and tell me that there were subsequent master plan approvals, and that is correct. But the overall number that I've just given you is approximately the same, because the intention was to build a lesser number of smaller units and concentrate on larger units, which would be more family orientated. This was an economic requirement at the time because so many little one-bedroom flats had been built in Liverpool, Manchester, and God knows where, which were unsold. So that was the reason for it. So the figures that Mr. Sillick has quoted need to be recast on the basis of what we're actually dealing with, not what was originally dealt with in 2001 or 2. The second thing basically is the council have engaged in a continuous amount of correspondence on whether or not the appellant was liable to provide affordable housing on other people's sites. This was a debate carried out with many members of CEC, and the upshot is contained in correspondence where it was pointed out that they should not represent this fact to planning subcommittee because it wasn't correct. That was not a liability. If you had a site because of the legal agreement that Mr. Dunlop has referred to, then your job is to comply with the terms of that legal agreement on your title. It's not the appellant's job to provide somebody else's affordable housing. As it happens, the affordable housing requirement under the original agreement had either expired or been provided. However, the appellant took the viewpoint that they should promote the development of affordable housing wherever possible. And that's why today there is already built a significant percentage, way above 15%. Okay, might not be 35% overall, but it's around about 31, 32% of the total, or would end up that way. I think that's where it is. It's quite clear to see. So just put that in context. This affordable housing matter has already been agreed by the council that the appellant is not liable to provide affordable housing across the whole of the site. And that's something which they conceded as between the council and indeed I think it was Turk and Connell at the time. It went on, the debate by the way did go on for about 5 years, something like that. Thank you.
Can I just to clarify that statement you made that I think you said the how affordable housing obligation is either expired or being provided. Is that because the numbers you've already provided on the site, this 31, 32% would cover the obligation in the Section 75 agreement?
Two reasons. One, yes, to the latter point, to the first point, the point you just made, and two, that the original Section 75 agreement had a time limit on the provision of affordable housing on the phases 1 and 2. The plan is attached to the agreement for all to see. We weren't there at the time, so I can only tell you that this is looking at it after the event. But quite clearly, properties had been sold to housing developers for development. I listed you the plots concerned and the consents that were granted. But at the time, they built properties and no affordable housing was actually provided by those developers or by Fourth Ports, none. It's only when we came on that we said, well, we've got to put this right. We can't have no affordable housing. We at least must have 15% of the expected 1,975 units. And in fact, we ended up, because of doing partnership deals with two of the largest providers of affordable housing, that's how we got the numbers up to where we are now. So the answer to the question is one, yes, and two, yes. So yes, okay. It had expired. But I can't talk about the expiration. I don't really know. It seems to me that it was a strange Section 75 agreement. You have an obligation to provide affordable housing, but then it expires in a fraction of time, and then nobody makes sure that it ever gets built. I know there were economic challenges at the time, but that's not an excuse for it not to have been provided, but it wasn't provided by anybody. And now the situation, which is probably a bit unsatisfactory, is that council comes along with a set of draft heads of terms for a new Section 75 agreement, somehow requiring the appellant to provide affordable housing over all the site, including sites that they don't own, knowing full well that that actually is just not right.
Okay, thanks for clarifying that. I'm going to park this discussion on the affordable housing detail until we get further on the agenda, because I'd quite to get the principal stuff done first. But I will give the council a chance to comment on that when we get to that point. And I think it would be question H. We can deal with it there. Are there any other points either the appellant or the council to make just in this principal discussion about whether I can require a new Section 75 or vary the previous one? I mean, I've got both party positions. Are there any final comments anyone wants to make? Ms Dunlop, you're shaking your head. Mr Nelson, do you want to? Okay, Mr Nelson says no either. Okay, so I've got that in my head. So question C, we covered this predominantly yesterday, so I don't think I need to go into question C. I've got the ownership plan, which we did discuss yesterday, and I've got the list that you provided also of the addresses across the site. There was probably one question I was just going to clarify. So the addresses you've given me are for the residential developments on the site, which is fine. For the bit to the south, below, I think it's Hesper's Crossway, I think you've listed on there the interests where they're not residential properties. So you've got, for example, like 1 times freehold, 2 times leasehold. 63 West Harbour Street, there's no detail. Plot U, there's no detail. Plot F, there's no detail. But I assume, are there probably multiple owners on these plots?
No, madam, they're not. That's the point. They basically, it's a single ownership. We've only,
Okay.
you asked us to list the individual titles, which we've done. So where a site has just the freehold title, that's
One
to make
title,
it simple,
okay.
that's how we did it.
That's fine. That clarifies that for me. So I think we can skip over question C, because I think we covered that yesterday. So question D, and this probably comes on to extension of what we'd already discussed, is whether a new Section 75 agreement would need to cover the whole site, or can it cover part of the site in the red line boundary? And I'll come to the council first on that one.
Yes, ma'am. So I think our principal position on this is it does need to cover the whole site that you're giving consent to and all potential development of it, because clearly just because the applicants only own part of it doesn't mean that there isn't consent being granted for the rest of the site. And therefore any U75 needs to cover all potential plots that could still be developed under this consent and consent granted. I think if you were minded to exclude plots, I suppose it's open to you to consider excluding plots that had been already developed out. I suppose our only caution on that, I suppose, would be that it's still in principle possible in terms of the outline consent granted and further AMCs coming forward to further develop those plots again. So but I think that's maybe an outside risk. Where we would be much more cautious was over any plots where there may have been NIDs and intentions of development. And arguments we always had yesterday over whether commencements occurred or not, because clearly that for those plots it's entirely open for further AMCs to come forward, and indeed that was touched on by both parties yesterday. That was something that will be further considered in terms of whether the AMCs will be brought forward for those plots. So they clearly need to be covered by the Section 75. The only further point touch on this topic, ma'am, is also open to you. Whether if you were minded to condition the consent or for the planning obligation to the consent to limit the extent to what parts of the site the Section 75, that the planning provision applies to. So if you were restricting down that the consent is only for part of the site or for the part of the site owned by the developers that have brought forward their application, then if that's the case, then certainly you could be limiting your 75 to the part of the site that consent is actually granted to. So I think we're fairly neutral on whether that's a good idea or not. But I raise it, ma'am, given the nature of the question and also the nature of the application and what is ostensibly being sought, what consent is ostensibly being sought for and has been argued for in the context of this appeal.
Can I just clarify, if I could carve out the developed plots? I know you said there's a slight risk there that potentially someone could redevelop those plots, but given that the extension that's being sought would be for 3 years, the risk is probably quite minimal.
Yes, and then that's correct, ma'am. I mean, I think it's up to you, I suppose, in terms of the extent of the area you consider necessary to be covered by the Section 75 agreement, and it needs to be sufficient to cover all the obligations you're seeking to secure. And it is open to you that if you wish to exclude the developed plots, then you could opt to do so. as I said, there's an element of risk with that, but as I've said, I do agree with you that for the passage of time and given those sites have been developed out already, that risk would seem to be reasonably small.
Okay, thank you, Mr. Dunlop.
Yeah, I may have misunderstood, but I picked up Mr. Nelson saying you could restrict the planning permission to part of the site. I just want to be clear. I mean, in terms of section 42.2, I was trying to look to see if I've got it in front of me. I don't think you can amend the description of the planning permission. You can't amend the planning permission under a 42 application. It's only a question of whether or not it can you can dispense with conditions. So I don't think you can change it. I've never heard of anyone in a section 42 restricting planning permission. Planning permission is there. Section 42 is an application to whether or not that particular planning permission should proceed with or without those conditions. I'm sure the word only is used in 42.2. I don't have it in front of me, but maybe whilst I'm talking, one of my colleagues could look it up and I could read it, read out the provisions of 42.2 to you. In terms of should it apply to the whole site or only part of the site, I think this is the key problem. The application, the permission is over the whole site. There's no rational, or it would be unreasonable to impose a section 75 only in part of the site. In my submission, that would be ripe for a legal challenge, essentially saying, right, you proprietors are going to be liable for this, and there'll be a different set of maintenance liabilities for common property under the original section 75. I say that can't be done. So you can't essentially have different liabilities for maintenance under the one permission. I say is the section 75 would need to cover the whole site, but then when the section 75 covers the whole site, you're asking the appellants to enter into an agreement to do things that they don't have the power to do. So that essentially then frustrates the contract, because you're asking, or not you, but the council are asking rather, apologies, the council are saying, oh, do you mind obliging yourself to do something with somebody else's land? That's like the council asking me to agree that I would do something to my neighbour's property. I don't have the power to enter into that contract. So that's the problem. You can't have the section 75 just on different components of the land. That might somehow be convenient for the council, but I say that can't be done. You can't, I say, restrict planning permission to only part of the site. And if you have the section 75 over the whole site, then you get into a situation where my clients can't comply with it. Now, I suppose section 75, the obligations, as I said earlier, under the circular, is that they have to be necessary and reasonable. How can they only be necessary and reasonable for part of the site? Why is the owner of number 4 Marina Way, I'm just making these addresses up, why is it necessary and reasonable for 4 Marina Way to be liable for the maintenance of X, but they're not, 16 Marina Way not to be? It might be convenient, as I said, for the council to try and do it that way, but it would fall foul of the circular as well. They're either required or they're not required, and if they're required for the whole site. And then I'm going round in circles here and being repetitive, but then you get into the situation where I say, well, the appellants don't own the whole site, and the council are asking you to. So anyway, I think I've made my point. I see Mr. Price's virtual hand is up, I should say. So
I'm just going to come and say something first.
Yes.
So I get your point. I'm assuming either I take the view that, as you're saying, the appellant doesn't own the whole site, therefore it can't enter into this agreement because it can't bind other parties, or I would take the view that you need to get consent of everyone to enter into a new site 75. I think that's appropriate, which is an absolute logistical nightmare because of the number of people involved. So, but I'm just putting that theoretically, that is an approach you could take. Theoretically, now I get what you're saying about there not being consistent maintenance obligations if you change that in a new section 75 agreement, and how that would be irrational over the site. I suppose it comes back to my point made earlier. if a new Section 95 was looking to secure different levels of contribution from those sites that are undeveloped, is that irrational, or is that unreasonable, or is that unnecessary?
I think Mr. McGavin might cover the contributions.
I'm not looking at in principle point
struggle,
here, not the level of contributions, but the in principle point.
The level of contributions is a separate issue from. Yes, the level of contributions, you plucked out the one that I probably don't have a clever answer to off the top of my head, but the level of contributions is different from the obligations in relation to maintenance and so forth. So I think it's something I'm obviously an advocate with duties to you, obviously to the inquiry. I think it's something that you could consider. I don't. It's not the same situation as the maintenance, if you like, obligations. We will still say that the proposed increase in the contributions is unreasonable and it doesn't reflect what is required. But I think we deal with that later on.
We deal with that later. I'm not asking. I'm not taking this as the view that you're accepting any of the contributions that have been put forward by the council. I'm just trying to get in principle.
I think in principle, I'm just conscious Norfolk Homes. In principle, you're allowed to look at material considerations at the date of granting or date of consideration of the Section 42 would allow you to look at updated positions. I think I would struggle to say that wouldn't allow you to at least look at contributions. As I said, we'll come on to say that the contributions suggested aren't reasonable. But the question I think you're asking me is, would it be reasonable to have different contributions? Or would it be automatically irrational, ultra vires, to have different contributions? I don't think I could say that.
Okay.
Can I just still come back on one point?
Yes.
Where, and I'm sure this, just so that I'm not misunderstanding it, where something's theory, I know that you said, there's hundreds of proprietors and you recognised that it'd be theoretically possible. I would say that to take the view that it was theoretically possible, therefore it should be imposed, I would say that would be so unreasonable in the Wednesbury sense to try and get the consent of 800 proprietors. It would only take one stubborn proprietor or one proprietor who didn't even respond, an absent landlord living in Hong Kong or something. So I think simply because something is theoretically possible doesn't make it
something you should do.
Doesn't make it reasonable. Yes, doesn't make it reasonable. It's enough difficult to get the kids to pick which TV channel they're watching without imagining what 800 people might take a view on. So it was just that it was a theoretical possibility. So I've noticed that I've just been asked a bit of paper.
Well, ask Mr. Price to come in just now. He's got his hand up.
Oh.
Yes, well, I was just going to say that this is really talking about the contributions generally. This seems to be just an attempt by the council to retrospectively collect money that they didn't collect before, and we'll come on to that when we talk about the specific contributions. But this doesn't seem to make any sense. Monies should have been paid or were paid. Now they want people to pay more money. And yet they've told one of the applicants on another site, well, make sure you get your application registered before the current master plan expires, so you won't have to pay any more contributions. When I heard that, I said to the development director, what, you're expecting that you won't pay it, but we'll pay it for you? How's that going to work? And then you ask us to write a letter supporting your application. None of this makes any sense. I mean, from the legal sense, you've heard from Mr. Dunlop what the position is. From a practical sense, it's just not right. But we can talk about the individual contributions when we get to it.
Yeah, no, absolutely. And I'll let the council respond, and I'll move on unless anything new comes up.
I think probably the main point, just to respond briefly, ma'am, is the nature of section 42. I agree with Mr. Dunlop to the extent that it has section 42 application needs to relate to the entire application that the original consent was granted to. So that much I would agree on. However, as touched on earlier in terms of what the court decision has stated, is it creates a new consent, and then you can apply such conditions to that new consent as you see fit. So I don't see any barrier to that being conditioned to restrict the area of the consent to the conditions you attach to it. Yes, and section 42 application that's been made is for the entire site. But as with any application, as with any planning application, where it's for an entire site, it's still down to the decision maker in terms of if it's the entire site is granted, or indeed is there conditions attached to restrict the extent of the site that the consent is for. So, that's just that point. I don't think there was much that changed in terms of the other points that were made from what I've already stated, ma'am, on this in terms of the lawfulness and what you can and can't do. I think I'd stand by what I've already stated rather than restating stuff unnecessarily.
Okay, that's fine. Thanks for clarifying that. Mr. Dunlop, do you want to come back on that point?
Yes, if I could. I've got section 42.2 in front of me, and I have to say that I expect there's some authority that I could helpfully refer to, but this is a bit of a curved ball that's come this morning. But section 42.2, I expect it'll be English authority, but 42.2 is in the exact same terms as 73.2. And it's on such an application, the planning authority shall consider only the question of the conditions subject to which the planning permission should be granted. Now, it's not, I say that the council they're leading you, and maybe not intentionally, down an ultra vires path to suggest that the conditions could be used to essentially alter the planning permission. The section 42 planning permission, the section 42 process is dealing with determination of applications to develop land without compliance with conditions previously attached. It is not there, and I know there's an authority saying that you can't change the description of the land, and I'm pretty sure that's a Scottish authority, but I can't tell it off the top of my head. But there's definitely an authority that says you can't change the description of the proposal. That's essentially if what the council are proposing is that you use the conditions to say you've got planning permission for 10 hectares, but the conditions say, but you can only develop 4 hectares to the northeast. That is changing the planning permission. That would be ripe for a legal challenge. I say you cannot do that. The conditions cannot be used to change the development which has been granted permission. You can only look at the conditions. I'm not going to dwell on it because I'm quite so confident about that point that, yeah, I think that would be, I would urge you, and if it's something that you want further legal submissions on separately, I'm sure both parties can make them, but I'm quite confident at that point. You cannot change the development that's proposed by use of the conditions.
I will reflect on that point. If I do need something further, I will write to both parties, but
Thank you.
I'll give you a chance to comment on that, but I'll reflect on that. Mr. Price, do you want to come in?
Yes, just to add to that point, this idea that you can add a condition to add back in money that you're looking for that should have been collected previously or wasn't paid, that just isn't right either, for the reasons that Mr. Dunlop has said. I mean, he's looking at the pure legal position, I'm looking at the practical position, but that can't be right. This is retrospective. I mean,
I was thinking it'd be more like Mr. Dunlop's outlined, that it would be notwithstanding the terms of consent, it only applies to those areas of land owned by blah or something. So it's restricting it very much to the plots that you guys own. I think that was
I think that would be. I mean, it's up to Mr. Dunlop to give the advice, and I think that's just a change. It seems to me a sort of, I think we're getting into the area of desperation that, we want to have some money here or some condition, we're going to do the etc. etc. This is a Section 42 application for an extension of time of an existing consent. It's going to be a new one. It doesn't require anything further. There's no risks involved. If the council feel that they've got individual rights to make demands on individual developers in the future, I'm sure they won't be shy in coming forward. But as far as the appellants are concerned, seeking to change the ground rules retrospectively, I'm advised by the appellant that currently they're carrying out about £1 billion worth of new development funding each year, and they've never had a council retrospectively change the provisions in this manner or seek to change them in this manner. And I must say I agree with them. It just isn't right. It would be a variation that is just not right. That's all I have to say.
Mr. Dunlop?
Yes, if I could just add, hope I'm not misunderstanding it, but if the suggestion is that a Section 75 could say, it's only the land owned by the appellant that will pay these increased housing contributions, say, for example, then that falls foul as well, because essentially Section 75 has to reasonably relate to the land, and it needs to be necessary and required because of the development. So what you would have then is, if you don't happen to be party to this appeal, somehow so the flats, I'll say we own plot 1 and Mr. X owns plot 2, I don't know the land ownership. It's got to be the same contributions for both, because otherwise it can't be justified by the council. They can't say, oh, well, they didn't come along to the appeal, so we're going to charge them £39,000 a house, but we charge the other ones £1,300 a house because they weren't at the appeal, and we can't get them to sign a Section 75. That would fall foul of Circular 3/2012, essentially to have neighbouring plots paying different sums of money, because you need to demonstrate that it's necessary. And if it's necessary for one, it's necessary for both. You can't simply escape saying, oh, well, it's going to be a bit difficult to try and charge them, so we'll just charge the people, the appellants. That's I say that you just can't do that. There needs to be uniformity.
Okay,
that's the only way they could. So that's the only way they could try and justify. I'm not saying they can justify the sums, but you certainly can't justify having different sums in the same app, because this is one whole site application. So one house pays X, the next house pays Y. That just, in my submission, just would not be lawful.
Okay, I'm going to move on. I think I understand harsh positions on that. I was quite like to do question E, which is hopefully quite a short one, before we have a wee short break. But it's not going to be a short one. I might review my views on that. This is just an update on the status of the supplementary guidance, and I don't know, Ms. Nelson, if you can deal with this relatively quickly.
Deal with it briefly, ma'am. At present, it's still to go before the planning committee again to make a final decision on it following consultation, and that's scheduled for September now. It was withdrawn from the last agenda due to a legal issue there isn't the day before, and it was felt that needed further consideration and the report properly updated before the committee could properly discuss it. So it's and should we have the date? Sorry,
10th of September.
10th of September now. That's when it's due to go back before planning committee. And the only other thing I'd add on that, is I think as we've previously submitted, is that the finalised supplementary guidance for an ARB submission remains a material consideration, as that's still the setting view of the council, and there's not been any suggestion of departing from that as the guidance, and indeed the consultation was purely to change it to being formal guidance rather than for supplementary guidance.
So I just want to clarify that, Mr. Dunlop, are you get any comment on that at all? Are you quite happy that's factually the position on it?
I have to say this was Mr. McGavin's initials beside it, so I haven't even looked at it. I'll ask Mr. McGavin if he disagrees. Oh, sorry.
Hi, can you hear me okay? Can you
Yes,
hear me
I can hear
okay?
you fine.
You can,
Yeah, I can hear you
okay.
fine.
There's
Yeah.
an echo in the room, so apologies for that. Yeah, I think Mr. Nelson was saying that it hasn't yet been adopted as non-statutory planning guidance, I think. Is that correct?
Yes, it's going to committee in September, and at the moment they consider
Yeah.
it still a material consideration to the application.
Yeah, thanks for the clarification.
Mr. Price, your hand's still up. Is that intentional?
I'm sorry to say I've been trying to get it to go down, but the
Okay.
computer's not responding, so apologies.
No, that's absolutely fine. We've kind of covered that part of the agenda down to point E, and we're going to actually go into the specific obligations after our break. Is there anything, final remarks that anyone wants to make on that part of the agenda at this point? Or is everything covered? Lots of shaking heads. Mr. Nelson, anything you want to cover? No. Okay, so let's have a break until, I'll say, 12:05. And we'll come back and we'll focus on natural contributions, and then hopefully get on to conditions. If you just want to
Thank you,
put your
ma'am.
cameras off and your microphones off, but stay on the call, we'll come back at 5 past. Thank you. Okay, welcome back everyone. I'll let everyone get their cameras switched on.
Madam, I don't have a question to ask, but as soon as I clicked on it, up jumped the hand again, so I'm sorry.
Oh, the hand's down from my perspective. I can't see your hand.
Oh,
So-
right, okay. Well, it's up on mine, so there we are. We've got a glitch. Don't worry about it.
Okay, I'm just wondering, Mr. McGavin is around.
Cameron? Oh, yes.
Okay.
Afternoon, ma'am. Can you hear me?
I can hear you, yes, absolutely. Is Mr. McGavin with you?
Yes,
His
what we've
cameras-
done is to avoid the kind of feedback, I think his mic is on, but his speaker isn't, but I'm sitting beside him or relatively close, so he can hear everything that's been said. So
Oh, it's okay, I can now see him. Just his camera wasn't on. I would make sure he was there.
Oh,
before
sorry,
we
is his
get
camera-
into the detail. Yeah, it's absolutely fine.
he's below me on my screen, but I don't know if he's in the same location in the blankety blank kind of screen that I've got in front of me.
I can see him now. I just didn't want to start until he was there because it's probably topics that he's going to comment on. So that's absolutely fine. So thanks all for coming back. We will start with question F. And I'm going to start with the council first and then come to the appellant. And you can cover all the points, all the bullet points there in a oneer, which is probably quite helpful. But that was the key points that I pulled out when I looked at the document. So I'll hand over to the council first.
Good afternoon, ma'am. I'll pass this over to Elaine, who's the expert on these matters.
Yes, hi. So my name is Elaine Watson. I'm a learning estate planning officer for the council, working for the strategic asset management team. Nice to meet you. So just to set a little bit of context, when the per unit rate of £1,366 was originally set, it was based on a contribution, the cumulative assessment of housing developments coming forward across the Granton Harbour site, the fourth quarter site, and the central development area. So at that time, all three developments signed up to legal agreements that had that rate attached to them. At that point in time, we estimated the costs of a primary school to be around 5 million. We now estimate the costs of a primary school to be around 30 million. Again, at that time, it was identified as a requirement for a 14-class primary school, even though the cumulative developments were estimated to generate 600 primary, non-denominational primary school pupils. 600 primary school pupils is the equivalent of a 21-class primary school, not a 14-class primary school where the capacity is around 420. The reason a 14-class primary school was agreed at that point in time was because there was expected to be spare capacity in the existing estate to accommodate those other 200 pupils that were estimated to be generated. There was a report to the Executive Council at the time back in 2005 about falling primary school rolls, and they estimated that by, sorry, I'm just referring to my notes here. So primary schools in rolls in 1997 had peaked at around 30,000. And there was a report in 2005 that estimated that they were expected to fall to 23,550. Now, we are able to now say that actually by 2013, the primary school rolls were 26,900. And by 2019, they had peaked again at 30,878. So that spare capacity that was expected at that time, nearly 25 years ago, didn't actually exist. So that's just setting a little bit of context. It's very difficult to unpick precisely all the increase in costs, but that's just a little bit of context. So to your questions, so I don't know if it'd be useful if everybody had the 24 SG in front of them right now. A little bit. Does everyone have that in front of them?
I've got it, yeah. And if you're referring to it, do you want to do it by page numbers so we can all quickly get to the right page? But I've got it. Hopefully everyone else has too.
Yes. So it's page it's page 27 on the document, but if you're on a PDF, it's page 28, I guess, the title page. Yeah, uses the number. So the actions that the contributions would be expected to contribute to are listed in the first table there. So that's a 21 class primary school, 31% contribution to 2 primary classes at Holy Cross Primary School. This is because the catchment areas for denominational primary schools are larger than non-denominational catchment areas. And in the case of Holy Cross, it extends into another contribution zone, which is the northeast. So the northeast, housing developments in the northeast would be expected to contribute to the remaining proportion of the action. 1 primary school class at St David's RC Primary School, that is its catchment area solely serves this contribution zone, and the other and additional secondary school places would be the other action or infrastructure that we'd expect the proposed development to contribute towards. And again, I think the existing agreement or the original agreements, they again assumed that there was space in the denominational primary schools at that time, and again that situation has changed. So I think that answers the first question. Yes. Okay, if we can move down to page 30 or 31, that is a map of the contribution zone. And so the contribution zone, it covers the non-denominational secondary school catchment areas of Craigroyston High School and Broughton High School. So it's the Craigroyston-Broughton contribution zone. That zone is split into 4 sub-zones, and the sub-zone in yellow is the sub-zone for Granton waterfront sites. So that we refer to that zone as CB1. Okay, moving to the next question. This is just an error from a template document. The amounts in the summary relate to a proposed development of 3 houses and 72 flats. Without knowing how many dwellings, flats, houses are proposed, then we're not in a position to say what the contributions would be based on our per unit rates.
Right, so should I just ignore that total contribution section in the document?
In terms of the summary, yes.
Okay. Okay, great.
Right, so the calculation. So the rates in the 24 SG, they're set out on back to page 27/28. So the second table, it says CB1 and it outlines what the per unit rates are for primary, secondary and full. The reason we separate it into primary and secondary is because if a proposed development is only expected to generate primary school pupils, we would not expect them to contribute towards additional secondary school capacity. That really only affects smaller developments. There's a note underneath that table. It's basically a caveat that explains that these per unit rates are based on housing output assumptions and costs at a particular point in time. When we receive an application, we will carry out a further assessment to work out whether or not the proposal is in line with the housing output assumptions. The housing output assumptions that have informed these per unit rates are on the next page, page 28/29, depending on. So in summary, for those, it's sites in fourth quarter, the capacity was 1,296. Sites in the central development area was 1,460. Sites in Granton Harbour was 2,145. Sites in North Shore, 528. And then there was another urban area site at Muirhouse Parkway for 142. So during the consultation period for this draft document, so the planning committee approved the draft 24 supplementary guidance for consultation in June 2024. And during that consultation period, the council received an application for 847 houses or dwellings within the Granton waterfront development framework area. Those sites, the dwellings proposed in that application covered fourth quarter, the central development area, and North Shore. And so at that point in time, assessment was done on whether or not the per unit rates in the SG and the housing output assumptions from this new application were in line with what we had set out there, and we found that they were different. So, I realised the figures that I listed for the sites, they were the revised ones, not the ones in that table. So can I just clarify that? So the 24 SG, the capacities for the Granton waterfront sites are fourth quarter 1471, central development area 1452, Granton Harbour 1883, North Shore 740, and urban area 142. And the revised housing output following this application that I just referred to, and another one at plot 35A on Granton Harbour, changed the housing output assumptions to the ones I listed earlier. Would you like me to say them again? Or is that nice?
Yes, if you could say them
I'll say them again. So the revised, the new housing
revised.
Fourth quarter 1296, central development area 1460, Granton Harbour 2145, North Shore 528, and urban area 142. The assessment that we then carried out on the impact on the education estate found that with respect to the actions, there wasn't a significant change in the actions. But there was a change in the per unit rates because they're based on the proportion of pupils that are estimated to be generated from a particular type of development. So the per unit rates were updated for the Granton waterfront development framework sites, and those are the rates that we are now using for sites in this contribution zone.
And those are the rates in table 2 in your response.
In document 54, is that?
54, yes.
Yes. Those are the rates now used.
Okay. Wait. Okay, so the numbers you've given me, they're the revised numbers. Those are the unit numbers now expected on the sites.
Yeah. Yes. Yes, I do have an estimated split of the housing types, which I could give you, but that might be easier to follow up in writing. Not sure.
These rates in table 2, are they applying to everyone? And do they substitute the rates in the supplementary guidance?
Yes, and well, any new sites coming forward would, again, would carry out the same assessment. Does the proposal, is that in line with the housing output assumptions that have informed those carrying out rates or not? That would be the first assessment. Has it resulted in change in what the education actions are? If they are broadly in line with what those housing assumptions are and there's no change to the actions, then those are the rates that we would now apply. We did consider whether or not when the supplementary guidance was at committee in December, whether or not the rates should be updated in that in the finalised guidance. But at that point in time, the planning application hadn't been granted, it was just minded to grant. So we didn't change them. But we would just go back to the fact that the guidance has that note to say that the per unit rates could change if proposals are not in line with the assumptions that inform them.
And when you say not in line with the assumptions, what are those assumptions? Is it the house flat split, or?
Yes, it's the house flat split and the costs of the education actions. So it's the actions themselves. If the actions stay the same, the costs stay the same, then the capital cost, then that would be no change. But we would look at whether or not there was a change in the actions and the proposed housing numbers. Because the calculation, it is based on the proportion of houses or flats that are attributed to, that contribute towards that development.
Okay, so you'll continually update these figures depending on what comes forward?
Only if they'll result in a significant change in what the rates are. But if they're broadly in line, then we wouldn't change.
So I suppose taking it another way, if, for example, an application came through for one of the plots on the site and it was all flats, and that was a change to your assumptions, so the housing flat mix was completely different, how do you deal with that?
Well, in this particular case, the number of houses is quite low across the whole contribution zone. So the revised housing output numbers for houses is 120, and flats are 5,451, of which we assume 1,108 have one bedroom. And so the flats that we use to calculate whether or not they are expected to generate pupils, so flats with more than one bedroom is 4,343. So,
and do you take account of when the build out is likely to take place? Because obviously a pupil hits P1, but they don't indefinitely stay at school. They've got a 7-year cycle. So how do you factor out that programming when it comes to these actions and the costs?
Yeah, our per unit, our pupil generation rates, they're basically an average of the amount of pupils that we expect to be on from that development at any one time. And whilst there might be peaks and troughs that throughout the course of the development, it's our experience that the roles are cyclical, and so we would need to accommodate pupils at peaks and troughs. In our experience, it takes about 8 to 10 years for peak pupil generation to occur, and once it does occur, it stays at that level for a number of years, and then maybe drops by about 15%, but that drop wouldn't change or wouldn't necessarily change the overall size of the school or the school required.
Okay, I'll let Mr. McGavin come in.
Thanks, Lance.
Steve, would you like me to relate the figures?
Right, is that on now?
Yeah.
It should be fine, Steve.
Okay now?
Seems sound on.
That's what sounds.
Yeah, that's fine from my perspective.
Yeah. Can you hear me now?
Yeah.
Hello? Can you hear me now?
Yeah, I can hear you.
You need to turn your sound up.
Oh, up there, sorry.
You're still.
If you put that and then put that on.
Here we go. Right, apologies for that. Will, can you hear me okay now?
Yeah, I can hear you.
Great, thank you. Yeah, I mean, I think just in terms of I think Charles is going to come in as well, but just listening to that, I think our main sort of concerns would be about the lack of flexibility, I think, as has already been picked up, and the fact that is there a robust mechanism in place to adjust the contributions if economic conditions change or if the development changes. I think the other thing would be in terms of any sort of disproportionate burden as well, making sure that the contributions aren't excessive relative to the scale of the project. And I suppose the other issue might be in terms of clarity over timing as well. So when are the payments going to be made? Is it pre-construction, post-occupation, during that time? Because all these things can affect, I suppose, cash flow as well. I think, Charles, you wanted to come in?
Yes, I think I was fascinated to hear how Elaine explained the figures. So in reality, if I could just explain them relative to the existing Section 75 agreement, they're looking for £12,875 per flat. This is what was in the Section 75 heads of terms sent to committee. The current Section 75 agreement is £1,366 indexed to the date of such consent. So the first question that comes to mind is, what have the council done with the money that they were due for the sites that I listed earlier? which were granted in 2004, 5 and 6. I have the dates, the consents, and I have the consent numbers, but to remind you, these are plots 26, 27, 28, 29, 30, 31, 3, 4 and 7A. And there are, unless, I think there's one tiny part that's mentioned by Mr. Silic yesterday, but the whole development, they are flatted developments, roughly amounting to some 900 plus units. And they were meant to have paid £1,366 upon planning consent, which dates I have. So my question is, what have the council done with that money, which is meant to have been put on an interest-bearing account? Do you have that money?
To be fair, I like the council, so I'm not sure it's totally relevant to my consideration of the appeal, what they've done with that money or whether it was paid.
Well, it's relevant to the figures, though, isn't it? When Elaine is referring you to the costs and figures of carrying out education.
From that perspective, yeah, it's relevant. Has it been taken into account in coming to the costs that you?
Yeah, that's what I'm saying. Yeah. Where is that? Where is that money? Is there credit for that money? Was the money collected? It's been on. I mean, it should have been on deposit. The last consent, I think, is 2006. So you'd have earned a lot of money in 19 years if it was on deposit. So where is it? It would come to several £1 million. I mean, it would. My calculation at the time, allowing for indexation for 3 years, was that it was about £1,600 per flat times 900 flats. I haven't got the exact number of flats, but that comes to quite a lot of money that should have been collected. And so my question is, what have you done with the money? This is clearly referred to clause 3.6 of existing section 75 agreement. There is a variation section at 3.8 in the event that the site which is conveyed to the council, the post of construction is less than 1 hectare. There's a formula for adjustment, but I'm not aware that there was any such adjustment. And this follows on from yesterday's input from the council, where they turned around and said, "Oh well, you're in breach of your agreement because you haven't paid us a sum of money on 2 of the sites." So my question is, what happened to all of these sites, and how do these calculations fit into what is going on? It would appear that basically what's actually happened is that council's worked out that it needs some money and is divided on a formula the number of places into the number of units. Mr. Silic will have been interested to hear that Elaine does in fact agree that the number of overall units, she's got it now 2145. So just I want to make that clear that your figures earlier this morning were not right. But my question basically is, these calculations are extraordinary when you also work out you're looking for £39,000 per house. These are substantial increases of contribution that are being required, and they're being required, I suppose, from the appellant across the whole site in respect of developments which are not even theirs, and indeed in respect of developments which are being carried out, and yet you don't give credit for the money. I mean, it just seems to be a very strange set of accounting principles. I don't know how you worked it out.
Okay, can we let the council maybe just respond?
Yes.
Well, any money that we've received to date is held in an interest-bearing account. I don't know precisely how much we have to date for the Granton Harbour sites or any of the other sites within the contribution zone. But it's held in an interest-bearing account. We haven't had to deliver the new primary school because the development across all these sites has stalled. However, following the grant of the permission for the Granton Waterfront Development Framework sites, That application also identified a new primary school site. We have carried out a statutory consultation to establish a new school on that site. We have appointed a design team to design and deliver, well, not deliver because we'll need to procure a contractor to deliver it, but we are working towards the delivery of that school or the new primary school. With respect to the other actions, they'll be carried out when they are required, but in the meantime, the monies that we have received are held in an interest-bearing account.
Okay, but take that a step further. In the supplementary guidance, you've got a list on that page 27 of the cost of the various actions you outlined. Before you've then attributed that to each flat and house, have you deducted from the total of those costs the money you already hold, and therefore the cost per unit should then be the gap between what you hold and what the ultimate cost is? You see what I mean? So has that money been taken account of in reaching the current figures of per unit rates?
Yes.
Madam, if I could just interject, I mean, I think it is extremely relevant to know, in respect of the Granton Harbour estate, the amount of money that is held on deposit. This is relevant to a condition in a legal contract, which the appellants have the benefit of. And we think that if you're going to seek to try and change this legal agreement and increase the charges in such a manner, you need to come clean and tell us exactly how much money you've collected and how much has accrued on an interest-bearing basis. I think it's something that maybe if you can't answer today, you should, if the reporter so requests, hopefully put it in writing, because I think it is relevant. It's been there for a long, long time. The other comment I've got to make is I really find it quite extraordinary that you entered into this agreement in 2002, 3, or 2000 and whatever the date of the document is, and you just told me that nothing's been done for what, 23 years, and you've taken money from developers to sit there. That's cost them money, and you've not used it. You've not actually provided what you said you were going to be doing under the terms of the agreement.
We haven't provided a new primary school site, primary school yet, because it's not yet required. In the meantime, we have had to extend Granton Primary School to accommodate pupils that have come forward from developments.
Wait, yes, sorry, I don't want to when was that though? When did you do that?
When was Granton Primary School extended? It was extended in 2017 and then again in, no, it was extended in 2014, I think, and then again in 2017.
So what you're saying, so if I can then relate that back to the agreement, I'll quote you what it says, and you've probably got it in front of you, but if you refer to clause 3.8, it refers to the payment being conditional upon the site which is conveyed to the council for the purpose of construction of a primary school at Granton. What you're saying is that actually never took place. No site's been conveyed, has it? You just said you've extended a school, but you haven't conveyed a site.
The extension to Granton Primary School is an interim action until the new primary school.
Well, that wasn't my question. My question is, you didn't acquire. My question is, can you confirm you did not acquire a site as provided for in the existing Section 75 agreement, clause 3.8?
No, we did acquire that site. The site next to Caroline Park, yes, that was acquired. But now the primary school has moved to a new site within the Granton Waterfront Development Framework area. It's on sites B3 and B4 within the Granton Waterfront Development Framework
Yeah, I'm quite aware of that, but you're saying to me you did acquire a site.
Yes, off the top
When
of my
was
head, off the top of my head, I don't know. I would need to check with their colleagues in estates the precise date. But the site next to Caroline Park was acquired.
And would you say that's the site that is? It's not a trick question, but is that the site that you think would be referred to in clause 3.8? I'll tell you why it's relevant, because of course it dictates the contribution. So we would need to know the date of the acquisition of that site, and also what was the size of the site? Was it less than a hectare?
Sorry, ma'am, I just question whether this is appropriate that Mr. Price has been allowed to cross-examine our person, ma'am. Specific things that you wish to ask them, sure, you can ask them, but the questions are for you, surely. It seems to be wandering off into a number of questions in relation to the old consent, but not really relating to the new consent that's been created through this application and what's appropriate to be applied to this new consent.
I was just sorry. I was pausing because I was reading the clause and trying to think how this is relevant to our discussion on the contributions the council is now seeking. And it's not relevant to me whether the existing Section 75 is being implemented or not. I mean, as I say, it's contractual between the council and the various landowners. I don't know where you're trying to.
Sorry, may I just draw everyone's attention to the definition section within the legal agreement, where it says primary school site means a site at Caroline Park, Granton, Edinburgh, or such other proximate location as may be determined by the council in agreement with Waterfront Edinburgh Limited for the purposes of constructing a new primary school.
I suppose for my benefit, I'd just like to, understand that the figures in the supplementary guidance or the new updated figures that you've put in your document 54, I suppose it's the cost. Do these costs reflect contributions and actions taken to date?
Yes.
So when you said the cost of a 21 class primary school is around 30,000.
30 million.
Sorry, 30 million, not 30,000. We wish it would be 30,000.
We wish.
The figure in the guidance is 32.9.
That includes an estimate on the servicing and refurbishing of the site. The construction cost of a 21 class primary school we estimate to be in the region of 30 million.
And what is that based on? Is it based on previous experience of constructing primary schools, or is it based on like Scottish Futures Trust benchmarking?
It's based on our experience of delivering new education projects. So we recently completed a new primary school on an LDP site, 19 Maybury. So that is the new Maybury primary school, and our costs are based on the cost of Maybury. So they reflect how much it will cost the council to build a school.
Sorry, Steve McGavin, do you want to come in? Mr. McGavin.
Thanks, Alex. Yeah, it was just a clarification in terms of the point about the new primary school. When is the planned opening date for the new school? I noticed on the website, I think it said August 2028. Is that still going to be the case?
That's what we're currently working towards, yes.
Thanks.
on mute. I guess the point I'm having difficulty is how it's transparent that money already held is already been taken account of.
Well, I can attempt to walk you through the calculation that has informed the revised per unit rate. But
it's more an issue in relation to the cost of the actions rather than necessarily per unit rate to start with. Because the cost of the actions are costed there at Q4 2022. And it's not clear if there'd been a line after the 82.4 million saying less contribution already made, and that brought you to 75 million. That would be very clear then what was left to fund.
yeah, I'd be happy to follow this up through a written submission to show the total costs minus what we've received to date and how the per unit rate has been calculated. I'm happy to do that. Or I can attempt to verbally describe how it's been carried out.
But based on your position today, you would say that 82.4 million already takes account of the money you hold on accounts.
Sorry, how much? 80?
It's the number.
It's a total list of actions under the Craig Royston education contribution zone, which comes to £82,475,912. So what I'm saying is that figure there takes account, because that's the figure that then is divided between the housing output to give you your rates. That's my understanding. So all I'm trying to clarify is that figure of 82.475 million takes into account money the council holds on account already paid from development sites in this contribution zone.
The amount in the SG doesn't take into account the money that we've received, but the revised per unit rate has taken into account payments that we have received.
But the revised rate's higher.
Yes, because in revising the calculation, the units that have contributed, so that are complete, who have paid, they have been deducted from the overall housing assumptions.
But is that right?
So I've got my spreadsheet open. I think it might just be easier if I try and explain it. So the costs of a 21 class primary school is £29,481,024. The estimated servicing costs for the new primary school site, because it is bigger than the site in Caroline Park, is £423,635. The proportionate costs for the two primary school classes at Holy Cross Primary School are £670,167. The proportionate cost of the extension to St David's Primary School is £852,075. In terms of total primary school cost, that is a total of £373,901. The payments we've received to date, £3,435,785. That results in a total of £31,930,116. And the housing numbers that are used in that calculation, 76 houses and 3,106 flats, because 44 houses have been complete and 1,237 flats with more than one bedroom. So they have been removed from the calculation that proportions the cost of the actions, and that's why the per unit rates for the primary school proportion for a flat are 9.
Okay, there's a hand up in the London boardroom.
Yeah, thank you. One important point there, the council have very kindly acknowledged that they've already received funds by way of contributions for the early phases of the scheme. Had the council chosen to start constructing the new school at the time they took those contributions, the build cost would of course been far less. So what they're now seeking to do by a retrospective change in contributions is penalise future developers on future phases for increased build costs. I just wonder how that's equitable when they've been sat on funds for so long. And there's a further point which I'd like to make as a commercial point, and it may not go to the sort of legal assessment of this application. In seeking to change the provisions for the marina, the council are looking at a dangerous precedent where no funder of a development could ever trust the council in Edinburgh again for a phased scheme. When we look at funding, it's done on a commercial viability basis, and that changes drastically if contributions evolve over time. This is coming at a time when Scottish housing is in a massive crisis, where inward investment and the willingness to invest in Scotland has been impacted by rent controls. And I'm sure everyone's aware that there's been a pretty heavy pause on new construction because of the issues in Scotland. And I think if the precedent is now set, it's going to inhibit further investment. It's a commercial point, not a legal point, but it's equally important.
I mean, I know at this point, I don't know if the council wants to respond to them or not. Then I get the points, but they're not totally relevant to me. I don't know if the council wants to respond to that or not.
Just quickly, in terms of there's maybe a lack of understanding of when some of those contributions were received. So I think, as we briefly touched upon when we looked at the legal agreement 3.6, it says that the contributions towards education are expected at point of initiation of development. And so if you look at when these consents on the completed sites were initiated, you'd be looking in particular at S1 and S2, plot 3 and plot 27, where those developments were initiated. I mean, in the 22-year lifespan of the planning permission principle, relatively recently. So we're talking 2016, 2017. I don't have the dates to hand. Plot 27 would have been even later than that. So I think in terms of the initial initiation of development for plots 28, plot 4, certainly I think they only equated to something in the region of 342 units. So it's not that we've sat on money and haven't built out a primary school, it's that the sites stalled, and now as the sites hopefully are going to come to a point where they're not stalling, and where we're dealing with this section 42 where further development is going to come forward, the impact on the education infrastructure needs to be addressed. We're at the point where that needs to happen now.
Yeah, and from an education perspective, we wouldn't think it would be reasonable for us to commit the entire capital funding for a new school without any certainty of when the rest of that capital funding is going to come forward. And it doesn't make sense for a council to build a school and incur the revenue costs of running a school that is not needed for the limited development that's come forward so far. But the council, we did apply for planning permission for the primary school, I think in 2006, but that permission has lapsed. So the council has always intended to build a school at this site, or for the Granton waterfront sites, but it has to be at the right time and when it's required.
I totally get that. It's a chicken and egg thing, isn't it? It's when you incur the cost for infrastructure, when you actually need that infrastructure, it is a difficult one. Can I just ask a question? Are there any sites that haven't paid their contributions?
I'm sorry, ma'am. I don't have that information to hand. I'd have to double check. It's something that I could look at, try and look at, and get you an answer before the end of today, or possibly just do it in writing after the hearing.
I mean, the reason I'm asking is that I can see how you've got how you come to the contribution. You've calculated the cost, you've taken off the money received to date, and that gives you a number, and then you divide that with your remaining housing that's going to come forward. Totally understand that. But if, for example, there are 500 units out there that haven't paid, then it doesn't seem right that other developers are kind of filling that gap if they're due by someone else. And I just wonder if that has been taken account of in reaching the figures that you've come to. I don't actually need the figures. It was just if someone give me a yes, no after lunch, that would probably be useful for me to know. It comes to that point as to whether the figures are reasonable and relate in scale and kind to the development. That's kind of the point I'm trying to get to, based on the changes from the supplementary guidance 2024 and the positions set out in your document 54. I'm happy for someone to come back after lunch and just clarify that, if that gives you enough time. If not, I can consider whether I'm going to ask for further submissions of that, or whether I base it on the evidence I've got before me.
If I may just pick up something on the council said about sites being developed. You remember yesterday they talked about, have you implemented, the appellant implemented their consents? Well, I'm looking at the records from the council, and I can tell you that it's plot 2627. The consent was granted on the 1st of June 06. And indeed, works have been carried out because the planning consents were extant. Same matter applies to 30 and 31, and 4 and 7A, because they were the same planning application. Work started on 4. And I think it is a very relevant question that you've asked, is those that were meant to pay, did they actually pay? Because I noticed that the figure that's been given of 3435785 as being the amount that's accumulated to date. I calculate that if all the developments that I've quoted, giving some reasonable start date, had been on deposit, you'd have somewhere around about £2,750,000. So I have to conclude from that the council didn't receive payment or couldn't get payment. Not really working out why these draft heads of terms that they're seeking to have as some form of condition should ask the appellant to pay towards somebody else's liability that remains unpaid. So I think your question is correctly framed, and I think we should see this information.
I think the council said they'd received around £3,435.
That's right, madam. But that's from
Are you saying it should be
some other sites.
So you think that figure should be higher?
Well,
it was 3 million. I'm sorry, it wasn't 3,000.
3,435,785 was the figure that Elaine quoted as being the total amount that you've collected to date.
Oh, that's what I thought it was.
Yes.
So
all I'm saying is extrapolating the figure. I have to disclose I trained as an accountant, but extrapolating the figure from the sites that I know where work had started as defined by the council, because I've looked into all of the planning and commencement dates. The figure that should have been collected from those housing developers under the existing Section 75 agreement, allowing for inflation, because you index it up to inflation before you collect the money, and then you add interest for a period of time. I calculate that approximately, I've done it in detail, £2,750,000. Which means that of the 3,435,785, they have collected £700,000 from elsewhere. They've referred to other development sites which are not.
Yeah, no, I get that. I'm just wondering, is that figure correct? I see the council discussing that figure. Have we picked that figure up wrong?
Which figure? The 3,435,785?
I'm asking the council because there's a bit of discussion from the council team. And I just want to be sure that that is correctly understood.
The payments received, the figure I gave was 3,435,000. Yeah.
Yeah, no, that's fine. I just thought it was a wee bit of confusion. I just want to clarify that was the right amount.
So what I'm saying, madam, is that appears to be extremely low if you take my calculation of what should have been collected by the council. I believe that the council did not collect or were unable to collect a large amount of the money, because we know what happened to some of the developers once they'd started work. Their demise followed, and a number of sites were taken over by liquidators. So I'm fully aware of the history, but they had started work, and therefore the money was due and payable.
Okay, then the question I just would like to know after lunch is whether the plots that have commenced development and were due to pay contributions, if any plots haven't paid contributions, has that been taken account of when reaching your per unit amount for the remaining development? I don't need to know who has or hasn't paid. If that's the case, I don't want to go any of that. It's just I can't suppose a point of principle. Have the plots who are due to pay and haven't paid been taken into account in reaching your per unit rates now for the plots going forward? But you can just give me that answer after lunch, because I don't expect you to have that at your fingertips at this point in time. And I say I'm not looking for reference to specific plots or anything like that. You have to disclose anything that's commercially confident.
We should have that answer for you, ma'am.
If you come back and you're having difficulties, you can let me know. But that would just, I think, help understand the amount you're now seeking. Okay, subject to that point, is there anything anyone else wants to raise on education? No. Okay, well, I propose we just stop here for lunch. We've come back at 2 o'clock, and we can hopefully get through the other points. Okay, so again, just put your cameras and your microphones off, and we'll reconvene at 2 o'clock. Thank you. Okay, I'm going to start by going to the council to start with, to come back on the point we closed on just before lunch.
Thank you, ma'am. I have looked into the question raised over the lunch break and confirmed that in two instances, for two plots, I haven't been able to find any records over the break confirming that they have paid. So we've confirmed it for all, with the exception of two. I know you said that you don't want to go into which ones they are. I can't say definitively here today. I don't want to say definitively that they haven't paid, just that I can't sat here right now and find all the records, and I'd probably need more time to go and research that matter. If it comes, particularly if it's going to come into your consideration, it's something that we can certainly confirm for you in writing at a later date.
Okay, well, I will reflect on that. I've got just a couple of follow-up questions and I want to kind of move on to transport, and just I'm trying to kind of come back a little bit where we got down into a bit of a wormhole and to pull back a little bit. I suppose the first point would be just reflecting over lunch and looking at that table in the guidance, supplementary guidance of the unit rates and the number of the housing output, and then looking at the table in the table 2 table in document 54. Was it intentional, or is it intentional that when you do the calculations on table 2 of times in output by the full contribution, you actually get a bigger pot than you would under table 2 in the supplementary guidance?
Sorry, I didn't have the tables in front of me. Could you repeat, please?
Oh yeah, of course. So I just did a broad calculation of times in the output, the housing output by the contribution, the full contribution for the figures in table 1, and did the same for table 2 to give me an idea of what the whole pot is based on that calculation. And I just wonder if it's intentional that when you do that calculation with the table 2 figures, it comes out to bigger pot than the table 1 figures in the supplementary guidance.
The table 1 figures being the
What's from the 2024 supplementary guidance? So all I've done in both cases is times output, the flats over one bed output by the full contribution, and the house output by the full contribution, add those together to get what I'm calling the pot, the contribution pot. And then I've done the same in relation to table 2 to get a pot.
Well, the housing capacity figures in table 2 are the cumulative assessment of all those sites, but the per unit rates, the revised per unit rates, have reduced the number of houses that have been used to calculate those rates.
But if I'm trying to establish the total contributions, so is it right that I times the output by the full contribution to get the total figure of contributions?
Yes, that should be right.
Okay, so I've done that calculation, and when I use the figures in table 1, it's a lot less than using the figures in table 2. And I just wondered, is that intentional?
I think I'd have to try and work out the calculations myself.
Okay.
Quite following it.
I can come back to that. I suppose the other question, which may make that calculation irrelevant, is based on the evidence I've got before me, should I be attaching more weight to the supplementary guidance 2024, which has been approved by the council, than your document 54?
Yeah, I'll just go back to the response I gave earlier on this, where the caveat within the SG explains that a reassessment will be carried out to ensure that applications come forward are in line with the housing output assumptions, and if they change, then they will be amended accordingly.
Okay, so that caveat would allow you to bring these other calculations in with similar weight to what's in the guidance?
Yes.
Okay, thank you very much. I don't know if the appellant wants to comment on that. Any final comments?
Nope, nothing more from us, unless you get anything, Charles.
Yes, I just would take up Mr. Sillick's point that when he supplies the information, could you specifically confirm that the plots 26, 27, 28, 29, 30, 31, 7A and 4, where work had commenced on all of them, that you've received the contributions that you were entitled to? I think we need to know that.
I'm not sure that's appropriate from my understanding of the case. I just want to know whether those where contributions haven't been paid, they've been taken, those houses or units have been taken account of in reaching the per unit calculation. It's not relevant to me which plots have paid and which plots haven't paid.
Well, it'd be relevant to the amount of money that is being asked here, wouldn't it? Because
that's why I'm asking to confirm that plots that are due to pay a contribution have paid a contribution.
well, mine's the same point. All I'm saying is
it's a level of detail, and I don't think I need that level of detail for the purposes of this appeal.
All right, madam. I mean, you can't calculate the figures without knowing what they are. But I understand the point. I mean, basically, that's fine.
I am going to reflect whether I need that information. It may come down to a response to my earlier question, but I'll come back to that. Okay, can we go on to point G, which is the transport works? And again, it's just looking for some kind of explanation as to why this would be required.
Thank you, ma'am. So in terms of why we suggested that the transport work, so that's a continuous cycle, the signal improvements to Granton Square are still required, is that transport impact in particular formed part of the environmental impact assessment that informed application 0100802 OUT. And that within that document, within the EIA, transport impact as a result of the development was identified in terms of construction during the construction phase of development, and also post-completion within the lifetime of the development. And the mitigation measures that were suggested in the environmental statement, which accompanied the application, and these are set out in the report handling that is before you, which I think is document 16. They're summarised within that, but the mitigation measures that were suggested at the time as part of the EIA was establishing a comprehensive footway and cycle network, provision of a pedestrian signing strategy, bus stops located throughout the development on appropriate roads, formalisation of the existing roundabout in Granton Square, incorporating a new site access for the development, and realignment of the carriageway, forming a new priority junction at Trinity Road, Trinity Crescent and Lower Granton Road. And four ports therefore agreed to fund a package of road improvements to mitigate the impact of the original planning permission in principle. And this was in conjunction with concurrent applications at Western Harbour and New Haven, and included the cycle route, the continuous cycle route from Lower Granton Road through to West Harbour Road, and signalling improvements at West Granton Road. We haven't had, as part of the application that was submitted Here in this section 42, we didn't receive a new transport assessment. So we haven't had any up-to-date information in terms of transport impact, which would suggest that these mitigation measures are still relevant and necessary and arising from the impact of the development. And so the council's position was to maintain that requirement. These improvements weren't only considered in terms of transport impact, but within the EIA, the impact of the development in terms of its integration with existing communities was also considered, and its sustainability of the scheme was also part of the planning balance. And again, this is all set out within that report of handling. But the environmental statement set out that the development represented an opportunity to allow greater public access to the waterfront with improved facilities for pedestrians, cyclists, and sailors. So the proposed cycle infrastructure, including the continuous cycle route, were considered as part of that integration. As part of integrating the site with existing communities, the developer agreed to reserve land for the tram to provide better connections into the city centre, as well as those contributions that we've already identified, the continuous route and signalling improvements. And again, there was also the ongoing development of the central development area. And so the continuous cycle route was considered as an important part of integrating the development of the harbour with that ongoing development in that area too. So in absence of any other information, we didn't have new information which suggested that, again, that the test in terms of being necessary and required. Sorry, you're on mute, if you're talking.
Sorry. We will come on to a general discussion against the test in a minute, but that was useful explanation as to why it's required. Does the appellant want to say anything at this point, or you can say something later when we come on to look at the actual tests and how they're met for each of the contributions?
Yes, just to make one point, there is reference in the existing agreement to infrastructure works and payments to be made by Forth Ports. Apparently the council demanded money from Forth Ports and there was a dispute on the payment of £1 million. And as a result of proceedings, the council decided or agreed to accept a much lesser sum, but on the basis that the money did not have to be spent for the intended purpose. There is evidence of this if required. So I just want to make it quite clear that the council have already varied prior to our involvement the infrastructure works contribution and took the money that they could use it, the money, the commuted amount of money, and use it elsewhere. I think to set the record straight, that's a relevant point. The other relevant point is that the continuous cycle route and the infrastructure and the roads, they've all been constructed, they're all there. I think the report, Madam, you would have seen that when you were present. Obviously, there's some works to the individual sites when they get developed to carry out the final connections, but the continuous cycle route and access points are in the main already been installed. That's part of the legal agreement. Forth Ports carried out these works. They were approved by the council and they were reported by the council as being carried out satisfactorily. The current estimate at today's prices of those works, all of them, come to about £19 million. So there's a very sizable expenditure that was carried out as part of this agreement. That's all I have to say.
Okay, thank you. I don't think, correct me if I'm wrong, when I was out, there's been no signalling improvements done to the roundabout, has there yet?
So there's no, to my knowledge, there's been no signalling works done to the roundabout. Also, again, to my knowledge, there's no continuous cycle route along West Harbour Road. I mean, there might have been there certainly has been cycle infrastructure in parts of the harbour area, but certainly to my knowledge, and I think if you just go on Google Maps, and of course you've been out to the site yourself, there's no continuous cycle route along West Harbour Road. And I think the other contributions that Mr. Price was talking about in terms of four ports, I mean, again, don't relate to the matters we're discussing here, is my understanding. I'm just trying to look at, but linked to, what does it say again? The waterfront corridor improvements, the eastern corridor improvements, and the lower Granton Road realignments. So they're not the matters that we're discussing right now.
My understanding, just on this cycle path, was that the cycle path was through the development site, not necessarily along West Harbour Road, but would connect kind of at either end of the development site. Is that
That's our
understanding
understanding.
correct?
That's our understanding, yeah. Bearing in mind that the development doesn't own West Harbour Road, that's a road that is owned and operated by the council. And it has been the subject of a CPO in order to expand the tram line, and those plans that we've seen include a tram line, pavement, and a cycleway, but they're not anything to do with the development. They're to do with the council's own plans.
My understanding is that the standing legal agreement, Ma'am, is in relation to Lower Granton Road and the cycleway, not the paths within it, the harbour itself, and then the works to signalise Granton Square.
Sorry, can you just repeat that your understanding of the cycleway is along West Harbour Road?
Well, I think it's Lower Granton Road, and then along linking into West Harbour Road.
Sorry, that's my error.
Okay, so how, I suppose the question is, how is that deliverable? I thought when you read it was through the development site from Lower Granton Road at Granton Square to West Harbour Road. So I thought you're going in, the cycle route would kind of link on to Lower Granton Road at one end at Granton Square, go through the site and come out the other entrance at West Harbour Road, rather than go along West Harbour Road. I thought it was to get the kind of connectivity within the site to link the existing structure out of the site.
That's our understanding.
Sorry, Ma'am, can we just have a few minutes quickly look into this?
Yeah, that's fine.
Thank you, Ma'am. Yeah, it's clause 6.1, the section 75 agreement. And it's a continuous cycle route from the development site from Lower Granton Road and it's Granton Square to West Harbour Road as detailed in the consent. So sorry, Ma'am, my colleague Chris had that right in the first place.
Sorry, does that mean it's through the site?
Yes, through the site or the southern edge.
Okay. Okay, is there any further comments on that, or I'm happy to move on to affordable housing? Now, we've covered this to a certain extent this morning, but I kind of parked it and to allow the council to come back to the comments that were made. So I'm happy for the council to comment on the figures.
Thank you, ma'am. We've kind of switched computers, so to speak, insofar as Steve's lowered the volume in his, and simply that might have been redundant because I think I've said what I'm required to say in terms of the affordable housing point. Is really kind of the balancing of the percentages, and I dealt with that this morning, so I'm not going to waste time, the inquiry's time, looking into that again. I wonder if then, Steve, if you get anything to say? Oh,
I was going to give the council a chance to come back based on, I think, the final comments that Mr. Price made, and at that point we parked it, and that was the comments about looking at the master plan approvals. It first the consent on the 31st of January 2014, which reduced the number of flatted units. And then questioning about the affordable housing on other people's sites. That was the point that we kind of parked it at. Also the point that the affordable housing contribution is either expired or being provided. And so I didn't give the council a chance to comment on that at that point in time. So I'm opening up to the council to respond to that now. But Mr. Dunlop, I do get you've made your points quite clearly earlier, but I'll let you come back to whatever the council say on this point.
Thank you.
Thank you, ma'am. Thanks for the reminder on the issues. Mr. Price referenced the master plan document and 1,900 homes, I believe. I think the council's position on this will be that, again, I think what I mentioned yesterday is that this is an appeal in relation to a Section 42 application for planning permission in principle. And that one of the conditions of that planning permission in principle, condition 16, I believe, is that it would allow the construction of up to 3,396 homes on the development site. And so I appreciate that the master plans that have come forward over a number of years have set out different housing numbers. So, I mean, 1,900 might have been the case in 2013. We've had different master plans since then with varying housing numbers within them. But the practical consequence of allowing the appeal and creating a new planning permission in principle effectively would be that the limiting factor would be that condition, 3,396 homes, residential units, rather. Again, we're also not asking the appellant to go out there on other people's land and provide affordable housing. That's not the case. The appellant has made it quite clear yesterday which sites they own, which sites they don't own. What we've said is that in the event that you allow the appeal and it creates a new planning permission in principle that affects the whole development site where new development can come forward, again, perhaps by the appellant, although they've suggested that that might not be necessary, that they've got extant planning permissions, but certainly in the case of other developers who might own different plots, they want to come forward. What we are saying is that the development plan and the needs of the city in the intervening 22 years since the grant this planning permission principle have significantly changed. So we can see in MPF 4, we have the math law that's set out in MPF 4. And I think for Edinburgh, that sets out a housing requirement of 36,750 homes. City plan, again, has identified a dire need for affordable housing and has set out a housing land requirement to meet the math bar of, I don't have the figure in front of me, but I believe it's around about 40,000 homes. And so the pressures on the city have significantly changed in that intervening time. We're looking at a planning permission in principle affecting this development site, the creation of a new planning permission in principle. And what we're saying is, where we're assessing some other schemes across the city, this 35% requirement is necessary to meet the housing needs of the city. we've suggested that it would be reasonable then to apply a similar requirement in this instance, with the caveat that we would accept that affordable housing has been provided to the level of 546 units. We're not asking them to be repeated again, to be provided again. What we're saying is that, and again, I went through, I believe it was my Carol Vorderman numbers earlier, it was Mr. Dunlop's comments, and I apologise for that, but 35% of the 3,396, and that would be the number that we would focus on, that the Planning Commission in principle would allow 3,396 units across the site if any developer was minded to do so. The 35% of that is 1,188 minus the 546 units that have been provided. That would be an outstanding requirement of approximately 642. Which, if you were to take that in terms of the housing that could still come forward on the site, so if we say that 890 units have been delivered, then in terms of condition 16 and the 3,396 limiting factor, that would leave 2,506. And 642 affordable units out of 2,506 would be around about, not exactly, but around about 25%. So it wouldn't be the 35% that's set out in the development plan, it would be less. So in this case, we've set out what the development plan position is at this time.
Is there anything the panel wants to add to that?
Yes, it just seems curious that the council, for their other contributions like schools, has a figure of 2,145 units. And yet Mr. Sillick refers to 3,345. I will tell you that the infrastructure that's been installed could not support such a high number of units. It wouldn't just be physically impossible. The sewage and drainage arrangements, even when they're upgraded, would not be able to deal with that. So there's little chance of there being that number. And the council have actually approved a master plan variation. The last one, which I take from Elaine's figures, as I think right, I've checked it during the break, 2,145 units, including the new application for plot 35A. I would agree with that figure. So Mr. Sillick's figures are not right. There is another issue that I raised before. This is made up ground, and development on made up ground is much more expensive and complicated. These are waters that were infilled many moons ago, and the council's policy on other sites of a similar nature appears to be that they wouldn't require, or it wouldn't be reasonable to require such a high percentage when your build costs have been inflated because you've got to deal with made up ground. So I don't think that it's correct to quote 35% on this site. As it happens, based upon our figures, we think we're going to be over 30%. I think we're running at about 32% across the site, and that therefore no further requirements are necessary. If the council feels on future sites that come forward by other developers, completely new applications, that they've got some right or requirement, then I'm sure they'll make them known. But as far as the appellant is concerned for the Section 42 application, we're satisfied that we've complied, and we've gone much further than the current provisions of the Section 75. We have voluntarily brought them up to date by what's been delivered, as opposed to previous developments that took place. As I said before lunch, developments took place and not one single affordable housing unit was provided, not one. They were all built by private developers and nothing was provided at that time. So I just think that's a matter that should be taken into consideration.
Okay, just based on that, so the condition is up to 3396 units on site.
Yes.
And the council's education revised figures, which you're happy with, Mr. Price, was 2145, and that came from this morning.
Correct.
And can I just clarify, when I look at the actual proposal in the city plan, it's got a number of units of 1546. Which is the remaining homes we built calculated from a 2021 housing land audit. I'm assuming then is that figure being superseded with subsequent audits? And I know there's a time lag between producing your plan and it getting through the system and adopted. So is that the time lag that actually there's more units that will be developed on the site, albeit, as Mr. Price says, perhaps not up to the 3396 given the infrastructure constraints?
I can't speak for the council where they've done calculations. They would have to do it, but based upon our calculations, we think our calculations are right. That it's pretty easy to project, and I think the council's education projections in numbers are right.
So you're happy with 2145 on the site?
Yeah.
Okay. Maybe the council
Sorry,
clarify. Yeah.
Sorry, Mum, we were talking amongst ourselves, and I missed part of your question. Could you just repeat it, and then I'll.
Yeah, I was just saying, just to a point of clarification. So we'll come on to the conditions, but the figure of 3396 is the up to the maximum number of units on the site, as per the condition. Then we've got the figure of 2145, which Mr. Price says he's happy with, that according to his figures, and that's what you've based the education contributions around. And then when I looked at the actual allocation, the EW2C allocation, it's got down 1546 as the remaining number of units to be built on the site, which is based on the 2021 housing land audit. And I'm assuming, maybe we can correct me, that is that perhaps there's been a time lag, so actually the current housing land audit shows a higher figure. I don't know.
So the housing land audit is currently undergoing review, so I can confirm that that's process that's ongoing. The figure that we set out, the 1500 figure, will be based off an understanding of housing that was delivered on the site at the time, and a combination of existing consents and probably taking into account the intentions of the master plan. So that it'll be a combination of those factors.
But it does say, it says remaining homes, it's got 1547, and it says remaining homes to be built calculated from the 2021 housing land audit.
Yeah. And so I think at the time, around about 2021, when S1, S2 wouldn't have completed, plot 27 wouldn't have completed, that would probably tally up with, in terms of what that number is. But again, the HLA is undergoing review right now.
And of course, that figure is indicative in a proposal anyway.
Yeah, it's an indicative figure. And as we've said, our position would be that the limiting factor for the site is that condition 3,396 that has already been delivered.
Okay. Is there any other comments anyone wants to make on affordable housing? No. Okay. Right. I'm going to go into question I, which is a general discussion on how the contributions meet the various tests in NPF4 and city plan. And I'd like this to also include a discussion around the flood defence obligation, and that's set out on page 27 of the council's response to my earlier procedure notice. So I'll start with the council. Obviously, I've heard what you've said already, so you can rely on what you've said, but if there's anything else you'd like to add about how the contributions would comply with policy, then this is your time to make those points.
And I don't think we've got anything we want to particularly add beyond what we've explained so far, ma'am.
Can you make comments in relation? Sorry, can you make comments in relation to the flood defence obligation? Bear in mind the discussion yesterday about ownership, responsibility of maintenance, liability, and how the contribution you'd be seeking would meet the test in the circular which are now enshrined in Policy 18 and your City Plan 2030.
I think, ma'am, we explained a bit yesterday of what our principal concern was in terms of just that there was ongoing maintenance, and there was the meeting of the NPF4 policies in terms of coastal policy and flooding policies, and it was relating to development having been having proper protections in place to allow new development to take place upon it. And our concerns that we set out in more detail yesterday was that if the development relies on these informal flood defences, that they are properly maintained for the lifetime of the development, to ensure there's not issues for the development during its lifetime. They explained that we accepted that if you concluded it, or you had evidence before you that the development did not rely on these flood defences to be within the tests of coastal flooding, and we wouldn't insist on this. But at the moment, there's not any such evidence, and we've not got the evidence to be saying that the development doesn't rely on these flood defences, which is why we think it's a central point and is entirely very much necessary for the development that there is sufficient obligations in place to ensure the maintenance of these flood defences. Not sure if that covers your question, ma'am. Sorry if it doesn't.
I suppose bearing in mind I suppose when you say flood defences, are you confining that to the sea wall, which is in the appellant's ownership?
Before that we refute the position on ownership of what defences are just in the appellant's control within our own submissions in terms of what was passed through title. I think it's already been touched on. The fourth courts that's clearly understood in their title and passing it that they did have control of these flood defences, and our position is that they do belong to the developers here, and our position is that those flood defences need to be maintained. I think if you're even if you take the point that the applicants don't own these sea defences, then our submission on that would be that in terms of the Section 75 agreement, then it needs to be on all the relevant owners to secure those sea defences. As far our submission as things stand, and in the absence of ever having been submitted a strategic flood assessment for the site, and for the whole site, we've obviously had ones for individual application, individual plots, and they've been referred to, and we've gone through that yesterday. In the absence of that, the site certainly appears to be reliant on these flood defences, and they are central to the safety of the site, and that's why we're setting out there needs to be a very clear set of maintenance obligations on those defences for the safety and security of the site, and in terms of just how high in the pot in terms of NPF4's focus on climate emergency and the need for developments to take account of it. That this is an essential issue that needs to be taken account of in terms of the ongoing obligations in terms of maintenance.
Okay, for the appellant, do you come back on this one?
Yes, just to reiterate, the existing Section 75 agreement is on all the titles, and there's a clear obligation to maintain the key walls, etc., which are within the development site. The position regarding sea defences which are outside of the development site, which are shown in the title ownership plan, has also been pointed out that on the FRA site-wide, it's been provided that if you assume, in the hypothetical, that they're not there, there is no flood risk. So I think this is amply covered. It doesn't require any further steps to be taken. In fact, one of the benefits of keeping the Section 75 agreement in its present form is that the obligations are robust and are being carried out, whereas what's being proposed is proposing something which is undeliverable. We can't deal with other people's sea defences. We don't own them, and they're out with the development site. So I don't quite know what the council is trying to argue here. I think the simple point is that existing Section 75 agreement is robust, fit for purpose. It's actually quite one of the things that's quite clear, actually, because part of it is, difficult to interpret, but it's quite straightforward here. And everybody who has title ownership across the site is liable to maintain, to contribute to the maintenance and repair. And that's exactly what's being done.
Mr Dunlop, do you want to come in then? I'm going to go back to the council.
Yeah, just very, very briefly, Mr Nelson said there the Section 75 needs to be on the owners. And I think that's the point we're making, that and we're not, or sorry, the appellants are not the owners of the entire land, the entire site, which the Section 75 agreement covers. And that's, I think Mr Nelson's recognising that that's the problem. And as I said this morning, you can't carve it up. Anyway, I won't repeat myself. I'm conscious of the time and so forth.
But just on that point, I was going to ask the council why you consider that the existing clause 11 isn't sufficient.
I think, ma'am, first off, just contrary to what Mr Price has stated, I think there has been a level of debate sort of over the years of what that clause is meant to mean and do, and has certainly been refuted in terms of who are the owners, who currently has maintenance responsibilities. And our view on it wasn't clear cut enough in terms of giving sufficient comfort that this maintenance would take place. I think the other major concern that we had with it was in terms of it didn't give the council, the planning authority, any oversight in terms of it to ensure that maintenance was taking place and ensure that it was to a satisfactory standard on an ongoing basis. And so it certainly tried to remove the obligations from it, the council ever becoming involved, and I recognise that. But it didn't provide any monitoring mechanism that the council could enforce in terms of ensuring that these key defences remained in place and remained well maintained. And so that was what we were seeking to address through the 75 obligation.
But would you have those rights anyway as Coast Protection Authority?
I think we spoke about that yesterday, ma'am, in terms of what discretionary powers we have to step in as Coastal Protection Authority. Unfortunately, that's, as we've also touched upon, that may be when things have gone drastically wrong, and there's then a question of whether we choose to exercise those rights at all and do anything because of the costs involved. And then our concern, why we had set aside in 75, was to ensure that the ongoing maintenance did take place, and you didn't end up in that scenario where you were having some more serious requirement or serious issues for the council to step in as potentially to step in as Coastal Protection Authority if it exercises its discretion to do so.
But you're not putting yourself in. If you've already got powers, okay, discretionary, then why do you need the Section 95? Because it's just giving you discretionary powers. All it says is you shall be entitled to. So again, you don't have to step in under Section 75. Likewise, you don't have to step in as Coastal Protection Authority. So what's the difference between the two? And equally, if it's to the recovery of the costs, this is not to cast aspersions on anyone, but it is only a contractual right to recover costs from a third party. That doesn't guarantee you will recover costs from a third party. So are you in any better position than you are as Coastal Protection Authority, and why shouldn't you just rely on the powers and discretion you've got under that rule?
I suppose on that point, Mum, the Coast Act is primarily about the erosion of the coast, and it doesn't cover flooding. So I think this idea that we have these discretionary powers to step in and maintain the breakwaters isn't necessarily the case. It does mean that if the council was to step in and carry out repairs, it would only be to replace like for like and not to enhance or improve the flood protection in any way. And it's very likely that we would only be able to do the bare minimum to consolidate a seawall in terms of preventing it from full collapse. And it would still then be at risk from further erosion and could potentially increase the flood risk. So the discretionary powers that we do have, I think, are very limited. And that was our concern, that they didn't specifically relate to flooding, and we didn't have the comfort that they relate specifically to breakwater repair.
Okay, does the appellant come back on that?
Yes, the position that Mr. Sillick is talking about is just impossible to fathom. We're talking about hundreds of millions of pounds worth of development, which have to comply on the individual sites with the requirements and conditions, which include flood risk assessments. The flood risk assessment shows that even if you assume that whether they fall or not, but we're now at least agreed there are some sea defences. But if they're not there, none of them are there, there's no flood risk. And the further calculations will be provided shortly, which show that the further information required by SEPA bear that out. I'm not sure that there's anybody in this world that could do drafting based upon what Mr. Sillick and indeed Mr. Nelson have said. But we want something which makes it quite clear that you've got to do something in such a manner that it is I don't know what it is. I mean, there's only one way of doing a repair or maintenance of a sea wall, is to do it properly. Because if you don't, it's a sea wall and it's keeping the water out, the water will come in. However, that's negated by the fact that if you had no sea walls and no breakwaters, remember that's what they're suggesting, everything is gone, there's no flood risk. So I'm not quite sure what this is all about. I think it's just a bit of a red herring, if I can use that expression. Not a red herring in terms of that we've got obligations. The obligations are there and they're being carried out, and they're being carried out successfully and in a robust fashion. That's what the appellants have requested, because they've got a sizable investment and an increasing investment, and no one's going to build buildings, particularly new ones, that are not going to comply with the relevant legislation per site. I don't think this is at all relevant to the Section 42 application for the reasons that have been stated previously. This is an outline planning permission in principle, and each individual site where there may be some different form of risk, etc. One of the reasons why this is relevant is the suggestion that there's got to be further inundation studies, which are actually about to be completed, and mitigation measures. And the council say, oh, well, how do we know the mitigation measures are going to be completed? Well, I would have thought that under the building warrant approval and the other bits of legislation that govern development, they will have to be completed. They'd have to be completed before they're first occupied. Otherwise, you'll be taking a risk. And remember, the risk is first and foremost for the developer. They don't want to see something preventable happening, and that should make everybody feel comfortable. And remember, there's more than one developer here. If Mr. Sillick and Mr. Nelson are suggesting that people like Link and Portobello Housing Association, which are now Harbour, are basically irresponsible developers of affordable housing, then that's very far from the truth. Not with my dealings with them. They're very, very careful. And our clients are equally careful. The appellants are equally careful in the way they go about. They're very well advised, and they use the best advice that's available and adopt best practice. To suggest that somehow you're going to put a form of wording into a document that's going to embellish that, I just don't see it.
Okay, I'll ask the council for their comments, and then we'll come to Mr. Gibbons to get his view on things as a resident.
Thank you, Mum. I just, we have taken further advice on this matter. Our colleague Gordon McCosh, who was at the hearing session yesterday, the manager of the flood planning team, unfortunately can't be here today, but he has given me kind of additional information on the role and the powers of the Coastal Protection Authority, and I suppose where we want to leave this matter is just to emphasise that those powers of the Coastal Protection Authority are extremely limited, and that we're not involved in the management and maintenance of structures such as breakwaters. Any powers that do exist under the Coastal Protection Act don't make these structures formal sub-defences. Gordon has obviously went on to highlight to me that I'm just reading out. Under the Coastal Protection Act, the council is not obliged to protect eroding coastlines. So it's not the case. So it could be the case that, you know, in certain instances, we would just leave private sections along the coastline to fail, where there's no public interest to undertake works. And he said in the case of a large structure like the breakwater, for the council to consider carrying out any repairs, we would want to ensure most likely that private funds were in place before we could take on that kind of endeavour. And so I just want to be clear that the council's position is the Coastal Protection Authority isn't an ultimate fail-safe against the failure of breakwaters.
Okay, now I understand your position on that. Okay, Mr. Gibbons, do you want to come in with your views as a resident?
Thank you, Mum. So just a brief history. I previously joined the council in a challenge to the previous S75 extension in 2018, and the council and I myself lost that case. Since then, I have taken a bit of a back seat in planning applications. However, subsequent to that, in 2023, Granton Central Developments, who are the owners that leased the land from Forth Ports in 2014, took me to the small claims court to claim for the outstanding public realm service charge, as it's called. Now, that is in my title deeds, whereas there's nothing in it about an S75. As Mr. Dunlop mentioned earlier, I can see nothing for an S75, but I can see references to a public realm service charge. Now that, as I say, that charge was brought against me in 2023, and Mr. Price's principals at that time decided to abandon the case against me. So I don't accept that residents within the harbour are liable for the charges or all the charges that are quoted or were quoted by PPA, the company Mr. Price represents. So turning now to the flooding, I understand it, and I have looked into the history of the site, that Granton Harbour, a significant part of it, is reclaimed land from the sea. So the question to me would be, what is preventing the sea from reclaiming this land? And to me, it is man-made structures that are preventing it from being reclaimed. Okay, it may not be day to day, but when the storms, such as Storm Babbitt, arrives, then that land will be flooded. And to the people yesterday, I would say, if you want to look at a model Storm Babbitt hitting the eastern breakwater and subsequently sinking 2 yachts and a small trawler. And when you have the model that simulates that, you have the correct model for simulating what's going to happen to 35A when Storm Babbitt hits it equivalently, because that part of the harbour is the furthest from Lower Granton Road and North Shore Road, and subsequently the furthest away from what was the original shoreline for Granton Harbour and Lower Shore Road. So that whole side, the Western Harbour, Western Defence, is just a mud brick structure that has no resemblance to the rest of the harbour, and that needs to be reinforced if any kind of further development, in my opinion, is going ahead, because that is the area of the harbour that I believe will most likely be flooded when the next Storm Babbitt arrives. So in terms of the S75, I don't believe I have liability in terms of the defences, the sea defences, either the eastern or western breakwaters. I don't know why only the western breakwaters mentioned in the S75. It isn't the case in the outline planning application. The outline planning application says Forth Ports are going to manage the entire sea defences. But by transferring their ownership, by leasing the land to Granton Century Developments, the offshore Jersey-based company, in 2014, they effectively abdicated their responsibility for looking after any of the harbour defences when up to 2014 they were entirely reliable. So this whole question has come about between some setup of shell companies, offshore companies, etc. And you saw it yourself in the plan yesterday. There's at least 5 or 6 different companies involved in the harbour defences, where up to 2014 there was only one. So I think there's a bit of a manoeuvring going on here in terms of trying to transfer the liability from Forth Ports to somewhere else. And me as a resident, being one of the ports of calls, they're trying to transfer that to. So apologies, I've rambled on a bit. So thank you very much for the opportunity.
Well, thank you. You're entitled to take your time and express your opinion. I'll ask the appellant if they've got any comments on that.
Yes, I think a very straightforward manner. The deeds of obligations make it quite clear that there's a joint and several liability for the maintenance of the quay walls and the infrastructure. And whilst I respect Mr. Gibbons' views, it's an opinion that's not supported by the facts. The decision taken at the time in respect of matters to do with debt collection for people that haven't paid, of which there were a few, was a commercial decision because what we wanted to do was to see what was necessary. Mr. Gibbons has quite rightly said that there was a risk from Storm Babbitt, but there wasn't a risk because we proceeded to, first of all, infill 4.1 acres of land, which in itself is a protection. Mr. Gibbons might call it mud, but in fact, at the edge of one of the boundaries, there is what is currently a temporary rock revetment, which has been approved by Marine Scotland, and all the necessary obligations have been carried out, and it has proven to be robust. There is planning consent and a detailed planning consent for the construction of a robust, permanent inner harbour revetment wall. We wrote to the council and asked them whether they would agree that this could be a sea defence. They declined to comment. Whether it be a formal sea defence or not, it will be built and constructed and designed to comply with the latest regs, so it will comply. It's a sloping rock revetment. The outer revetments, which Mr. Gibbons has not referred to, the breakwaters, they are substantial. I'm sure Mr. Gibbons will be able to confirm. He might have walked down there. There's literally several 100,000 tons of rock, which form the barrier to the edge of the site, certainly on the western harbour, the western wall that we're talking about. But equally so, there's another protection because there's a very similar form of construction either side of the eastern sea wall, where there are breakwaters, which are very, very substantial. And Mr. Gibbons should hopefully be comforted by the fact that the current investigations and reports that have been carried out have shown, even based upon the fact that you assume that none of these sea defences, no walls, no breakwaters, nothing's there, that there will be no issue. And that, to me, is the basic answer. I don't think it's appropriate for this particular hearing to be dealing with Mr. Gibbons' personal situation, and it would be wrong for us to discuss it. It's not something which we are able to do under the Data Protection Act. It's suffice to say that all of the title holders who are obliged to pay are being charged for the maintenance and repair, where necessary, of the quay walls, sea walls, which are inside the development site. We are reliant, as you can imagine, something the council haven't taken or mentioned, we're reliant upon the support of the breakwaters because they support the wall. The breakwaters are owned by others. I think it's been suggested that, you know, we've got no way whether we go after them for money, we'd get it. Well, that may be so, but I think Forth Ports are still a very substantial entity. And I believe that the Jacobber Cliffs family companies are substantial entities. And the suggestion that our clients are only, the appellants are any other than substantial is of course entirely incorrect. The fact that they are an international fund with an overseas base, though they've got big representation in the United Kingdom, that's not something which is going to cause an issue here. So I hear what Mr. Gibbons says, but I don't think that anything he has says has got anything to do with it. Mr. Gibbons and I have spoken. I have to say to him, I've got nothing, I can't tell you about what went on with Forth Ports and the council at the time. I wasn't there. You might have been there, but I don't think you'd agree with me that you weren't involved at the time. You didn't get there to 2013. And all this stuff happened around the 2001, 2003. But Forth Ports did, and you haven't mentioned it, install a very significant and expensive sheet walling down next to the harbour. It's there for you to see at the moment. It's most substantial. So I don't think Mr. Gibbons is right to say that only a bit of earth and mud is keeping the water out. There are some, the Western Harbour is actually protected by this sheet piled wall, and will be further protected by the inner harbour revetment wall, which at the moment is being specified so it can construction can commence. For all those reasons, I think that the current arrangements are robust. I think they deal with everything. If one particular resident or title holder decides that they're not liable, well, that's up to them. But at the end of the day, the legal agreement is there for everybody to see. And if it needs to be tested, then that'll be up to our clients. But at this moment in time, we have our instructions, and we are dealing with it in the manner which should keep the site safe and allow the developments to take place. Thank you.
Can I just clarify, when you mentioned you've got an agreement, is that the deed of conditions you're referring to?
Sorry.
Applies. Are you referring to the deed of conditions that applies to everyone's property?
Yes, I am.
Okay, just to clarify.
And all the titles, yes.
Yeah. Mr. Gibbons, do you have anything you want to come back on and reply to?
Well, just as Mr. Price has mentioned, I wasn't there when the original 2003 outline planning application was signed. But just reading through it, it says Fourth Ports Development Limited has stated its intention in inspecting, repairing and restoring the breakwaters at Granton to good condition. The ongoing maintenance and upkeep of the breakwaters is to be carried out by a specially created management company whose responsibility will also extend to other common parts of the development, such as the public realm area. Now, that's in the outline planning application. And as far as I'm concerned, that is a reserved matter that has not been applied. Okay, I understand that housing is the priority, but I believe that Fourth Port still have a liability, especially as they're still the freeholder for the property, in maintaining these structures. And Mr. Price and I obviously disagree on that.
No, we don't. We actually do. You know something? We don't. We do not disagree upon the ownership of the breakwaters by others and their responsibility. If you thought that, let me tell you, I totally agree with you. Fourth Ports are, together with the Granton Asset Company, which is the close company, they are responsible for the breakwaters that they own. And in fact, they're more responsible to us, that includes you, Mr. Gibbons, because as I said, if you've got a wall and it's sitting on top of some land, the support to that wall, which is outside of the development ownership or development itself, that is the bit that we rely upon. They owe us a duty of the support, so they've got to maintain it. And ultimately, if they don't or something happens, then ultimately it'll be up to the Coastal Protection Authority to use their discretionary powers, although I'm not quite sure that's what the Crown meant when they gave them this responsibility in the 1940s. That's not what it says, but if that's what they want to rely upon, that it's purely discretionary, I think it's an obligation. They're the final port of call. Of course, they don't want to spend money that they can't get back. That happens to all of us. We don't want to spend money that we can't get back, even though we're entitled to get it back. But sometimes these things happen. At the end of the day, got to keep the place safe and got to keep the place repaired, and that's what's happened.
Mr. Gibbons, did you see the title plan that was produced by the appellant?
I did.
Okay, yeah, because that does show Fourth Ports and Granton Assets Limited ownership, the bits they own of the breakwaters with the wall in between.
Well, it does show that, as you say. Thank you for pointing that out. But is that reflected in the title deeds? How is that?
Yes, it is. That is. So, Mr. Gibbons, what we did was we did a photogrammatical survey. You realise that the revetment itself slopes down into the water, so you can only do so much from these very high definition drone operated machines. But we do know if the tide is out, you can see the rocks go for 6, 7, 8 meters out from the edge of the boundary of our site. We don't know how far down they go. Obviously, I'm not an expert, but I should imagine they go down many meters because they go down to the depth of the water. But that photogrammatical survey was compared with the title deeds and a title research. It was a big undertaking work to get it done by Turk and Connell and so forth. So everything married up, and that's how we know who owns what. That's the position. But I agree. I agree with you that they are liable. They shouldn't actually be here today, but they are. In fact, they are liable for their part.
Oh, thank you. I'm glad we agree that I have no liability.
Not for that part, you don't. No.
Okay. Let's move on from the seawall, and I'll give the appellant a chance to comment on how the contributions the council is seeking would meet the test for planning obligations. Is that you, Mr. Dunlop? Maybe you've covered it already, a lot of it already, so if you have, that's fine.
I have covered it, but maybe just very briefly, in terms of, it's the same point that I was making previously, but let's just maybe use another example. And we were talking about education contributions earlier, if the education contributions were to be £39,000 a house, as opposed to 1,300, then if it's only going to apply to the appellants, the appellants essentially are paying a sum of money which all the other owners of the whole site, if you talk about them cumulatively, are not paying. And therefore, you've got a situation where there's a kind of shortfall, and it doesn't represent what the cost is going to be. I'm sure I'm not putting this forward the way I intended to when I opened my mouth at first. Essentially, what I'm saying is, because of that unfairness, that means that it can't necessarily, if the contributions have to necessarily relate to the project, and everybody else that owns properties on the site is only paying 1,300 and the appellants are paying 39,000, then that can't properly represent what should be the charge to the appellants. But essentially, I'm covering the same ground that I did earlier this morning. It has to cover the whole site, and as soon as it covers the whole site, that causes problems. I don't think I've got anything further really to add about the financial contributions.
Okay, any final comments?
It's really just an example of the difficulty in trying to carve up a Section 75, or alternatively have it for the whole site, where the appellant isn't the owner of most of the whole site.
Yeah, and you've covered that, and I totally understand your position on that.
You.
Any comments from the council? Final comments on this point before I move on?
I don't want to retread old ground, ma'am. I think just briefly, I think we are saying it's Section 75 for the whole site as would be consented by this new consent. It's principally sought, and all the contribution obligations are fairly shared by all developers within that site. I think as we've touched on before, the written submissions, then it's certainly not unusual for the council to be receiving applications by developers who don't own the whole site, or indeed maybe don't own any of the site when they make their application. That certainly doesn't mean that we don't seek Section 75 contributions, and we would have to seek it against the proprietors. I take the point that there's difficulties with that, ma'am, but I don't think that it renders it at all unreasonable the council seeking development contributions in line with its development plan and its guidance. And that's all we're seeking to do, ma'am. Certainly not seeking to apply any sort of special case here. We're simply seeking to be reasonable as we would be to any developer in the city in terms of what obligations currently apply under the development plan. That's all I've got to say.
Okay, I understand your position. It's very, very clear too. Okay, let's move on to point J, and this is really for the appellant to clarify their position. I think I said one of the written submissions, I think it was in response to the procedure notice, that the appellant stated that the imposition of financial contributions would be unlawful as we contrary to the principle established in ELSA against Aberdeenshire Council. And I just wonder, in light of where we are today and the discussion we've had, is that still the appellant's position, or has that position moved on and it's more based on the arguments that you put forward today?
Yeah, it still remains our position. I mean, essentially, the point I was making there essentially was just immediately before it, in the last few minutes, is the fact that the financial contributions will be imposed upon the appellant, but they're not going to be imposed upon anyone else in practice, because the Section 75 is only in respect of the appellant, despite covering the whole site. So it's unenforceable against the other owners.
So it's that unfairness and relationship.
Yes, and it doesn't. Yes, and I can't. I mean, you need to hear from other witnesses in relation to whether or not they reflect the costs. Obviously, Mr. Price has raised a quizzical eyebrow, I think I could say, in terms of the education contributions. I'm not commenting on the numbers, but in terms of the fairness point of view, yes, I'm simply saying that it's unfair and it's unreasonable in the Wednesbury sense.
Okay.
Other than that, I'm just be repeating what I've said over the course of today.
Okay, and Council, do you have any comments on that at all? You're happy to rest on what you said?
I think, ma'am, you have a reasonably detailed written submissions on why we say it's LSIC compliant and the specifics of LSIC. So I'm not going to rehash that. I think we struggle to understand Mr. Dunlop's point he's making here. The consent sections, the section 42 sought is for the entire site, and we're saying 75 should be applying to the entire site. And if that's the case, then the obligations are being applied to all developers of the site. It's not true to be saying that it's only to one specific aspect of it, or this particular proprietor, or it's unreasonable. We're saying it should be applied across the board.
I get your point. Saying it should be applied across the board, but do you get the difficulty that entails, that you then have to get consent of everyone who has an interest?
We absolutely understand that there's practical difficulties with that. I think all we'd say with that is the choice of the applicant to apply for section 42 where they don't own much of the site, and that's of their own making. They could have applied for a full application for the part of the site they own, and the decision should be straightforward. But unfortunately, it's not. We acknowledge it's not as straightforward as it might be, but that doesn't mean that it's intrinsically unreasonable to be seeking the necessary obligations that arise from the particular development.
I guess putting that back to you, Mr. Dunlop, on behalf of the appellant, would you accept or do you agree that regardless of the land ownership issue, which it does add a layer of complexity, this development should mitigate any impact that it has on infrastructure?
I'm not sure I understand the question. Sorry, ma'am. Could you repeat that?
Okay. The purpose of Section 75 is to, in essence, make a development acceptable.
Yep. That wouldn't otherwise be acceptable.
Yeah.
Yep.
So it's to mitigate impacts of that development on existing infrastructure, things like that. So what I'm putting to you is kind of the reverse of what the councillor is saying, is that kind of forgot how I phrased the question. The land ownership complexities shouldn't negate the need to enter into a Section 75 agreement if that is necessary to make the development acceptable.
Well, I suppose the first thing I would say is it's not necessary to make the development acceptable. The development's already been determined to be acceptable, subject to the pre-existing Section 75. Now, I think one of the problems we have, or two problems. Firstly, the Section 75, and I've gone over this, but the Section 75 that's proposed will cover the whole site. And what the councillor asking us to do, or sorry, asking the appellants to do, is essentially obligate us to do things on property that we don't own. Now, the second, the other principal difficulty with that is that it renders the agreement challengeable insofar as it's a defective agreement, because what they're asking us to do is something that's impossible. Now, they say it's fair and that everybody will pay their fair share, but it's not enforceable against... the agreement won't be in the name of any other party other than the appellant. So essentially what will happen at the end of the day is that it's not going to be enforceable anyway, but the council will come to the appellant for things relating to land which the appellant has no control over and has no interest in. And I think it's an unsatisfactory position just simply for the council to say, oh, well, they applied for it, so they're just going to have to live with it. It still has to be a lawful Section 75 agreement. And the way around that, of course, is to have the existing Section 75 agreement. That's the way around it, because we've talked at the outset whether or not, my primary position is that the Section 75 agreement does essentially transfer with the Section 42 because it's linked to development of the site. But there's a way around this insofar as if the council accepted that, agreed that the Section 75 transferred, then that would be another way around it. The old Section 75, if you want to call it, or the existing, the only Section 75, could be agreed between the parties. That may be probably the best solution that's out there that would be manageable, but it still obviously has the problem that there's certain parcels of land that we just simply don't own, or the appellants don't own. I don't know if that answers your question, ma'am. I'm conscious I'm repeating myself, but equally, I suppose we're all to a certain extent going round in circles with this.
Yeah, no, I know it's a difficult one.
Yeah.
And I think I'm going to end the discussion on the Section 75 there. And move on to conditions. And actually, just bearing in mind time marching on, I was just going to rephrase the first question and actually just ask, I suppose, does the appellant have any difficulty with the conditions that the council has proposed, bearing in mind that they largely reflect the conditions already imposed in the 2019 consent? There have been some conditions added to reflect differences in policies, some requirements added around sustainability statements, for example, biodiversity enhancement plan, things like that. But I suppose just to short-circuit it, are there any concerns that the appellant has with the conditions proposed by the council?
Well, if I can speak now, no, we don't have any concerns at the moment with these.
Okay. And I suppose I'll put this point to the council then. Do you think anything additional is required to secure the mitigation measures required to ensure there's no effect on the SPAs? And I wondered if conditions 7, 8, 9, 10, 11, 12 in effect give sufficient protection for the SPAs.
Thank you, ma'am. I suppose we previously in written submissions commented on the habitat regulation appraisal that was submitted, I think dated January 28th, 2024. And we've commented on the ecological impact assessment that was submitted as part of the application for 35A, which has been referred to within this appeal. Our biodiversity team has obviously identified concerns in relation to the survey work that was undertaken. So, a number of the SPAs are designated because of their winter and breeding bird interest. So our observation stands that survey work wasn't taken during the breeding season, and there was no additional winter bird surveys. Again, that's all in our written submissions. Don't really want to go into any more detail, but I think in the absence of updated survey work, we couldn't realistically suggest any further conditions to protect the SPA. We have obviously suggested a biodiversity enhancement plan, which could have positive effect, and that's in line with Policy 3B of MPF4, and indeed a city plan as well also has its own biodiversity policy. But I would agree that the conditions kind of from 7 on, there's a lot of environmental conditions there, that they all came out of the environmental impact assessment that was submitted in 2003. So those are mitigation measures that have been suggested directly out of that piece of work. But again, I would just highlight that, no additional work there has been undertaken. Sorry, not that it hasn't been undertaken. I accept that a habitat regulation appraisal has been submitted.
And I know I have your position on that. I know you don't necessarily agree with what was undertaken, so I understand all that.
But yeah, so I mean, what we can say is that those mitigation measures were considered acceptable at the time, and that we don't have any new information to suggest they should be removed. And I couldn't realistically give you any additional conditions beyond that.
I just had a couple of questions. In some places it says, for example, to give you an example, condition, you've got, I suppose, looking at conditions 3 and 6, just condition 3 and 6. And it's a small point, but condition 3, for example, says before any work on each phase of the site is commenced, which would then kind of make sure your AMSC applications refer to plots, which is entirely sensible. And then condition 6 is, for example, says no development shall take place on the site. Now, I just wondered, it's a practical point and how this has been dealt with under the existing planning permission, whether in that case you'd expect the programme of archaeological work and the scheme of investigation to cover the whole site, or again relate to plots. It's more that enforceability point and making sure they're specific enough. Should things that refer to the site refer to a phase on the site as opposed to the site as a whole?
Yeah, I think we'd be happy with that approach. I think I've taken the wording from the original consent, probably, where it was at a start point and very clear, but I think certainly I wouldn't disagree with the approach you've suggested.
It's just a practical point, whether, because I'm not assuming you would get it for the whole site, you would get it for plots as plots come on stream. Okay, and I wondered if condition 8 is necessary, if SEPA have their own guidelines and they've also got their own powers as a regulator. Do you need a planning condition on top of that?
Again, Mum, the reason that this is included is because it's a direct mitigation measure identified in the EIA.
Okay.
So because of that, and in absence of any other information, I didn't feel confident taking it out. So that's why.
So the appellant's got no issue with it either. Okay, that was the only comments I had on those. And I did ask a question as to whether any additional condition is required to secure delivery of the approved master plan or the approval of a new master plan. And I just wonder if the council can give a view on that.
So in terms of whether to condition the delivery of the existing master plan, I suppose my concern with that would be that the appellant doesn't own all of the land, and that there's also a level of uncertainty that we've all accepted in the sense that the flood risk assessment, that there's still further work ongoing. We don't know the outcome of that. We don't know what the implications are for various plots and for the whole of the land. So if we were to condition delivery of the existing master plan, and it then turns out at any point in time that it's not deliverable, then that might become problematic.
Okay, yeah.
Sorry, do you want to come in?
No, I'm just saying, I can see your logic to that one.
Whether we should condition the approval of a new master plan, and again, I'd go on a similar line with that. I think I'm not sure it would be reasonable to condition a requirement for a new master plan, because I'm not entirely certain who would produce that master plan. Again, given that the appellant doesn't own all of the land, is it reasonable to condition the provision of a new master plan?
Do you think there's enough in, for example, the actual proposal in the city plan and place 4 in the city plan to give enough comfort as to the kind of guidelines or design principles around the site?
I mean, there are certainly within place 4 there are development principles, but whether and we would certainly assess. We'd be looking to assess applications against those development principles. That's certainly what we've done in the past. Could there be a condition around that? I hadn't thought about it in that way, possibly. But in terms of any form of new detailed master plan beyond those that have already been produced, I wouldn't. I think I can see the logic in it. I think for large sites, I would agree that a lot of the time it's very sensible to have some formal guiding document in place with those kind of principles that are set in city plan. I think they do give us a degree of comfort. Whether we need a formal condition of a new master plan, I'd be uncomfortable in how that might affect other people's land, and in terms of people like Mr. Gibbons, who's here today, having a say on what that might look like. I'm not sure it would be reasonable.
Okay, no, that's fair enough. Does the appellant have any views on that, or would you agree with the kind of council's view?
I don't think we've got anything further to add on that.
Okay, and on to the last question, and this was the appellant's proposed condition in relation to plot 35A. And I guess just an explanation to why this is necessary in the context of this section 42.
Yeah. I mean, it's not necessary. It was just there simply in relation to show what we were being asked to do in terms of plot 35A. It's not necessary for this. Yeah.
We have in fact, Madam, written to the council under 35A suggesting this condition, to which we haven't had a response, and hearing, because things have moved on with SEPA, etc. I think it would be appropriate that this inner harbour revetment wall is built, because it will afford protection.
Mm-hmm.
And I'm actually surprised that nobody's actually come back and said, yeah, that's a good idea, but they haven't. So since somebody wanted to conjoin what had happened on 35A and use it for the section 42 application, this appeal rather, we thought, well, why not put it in here? Because I think it's an eminently sensible condition, because it affords even further protection to the site. Particularly, it's a very long sea wall, by the way. Because you've seen it. It's a long way. It will afford enormous protection, and hopefully make someone like Mr. Gibbons in particular feel very comfortable that there's another piece of engineered structure that protects the land from basically the inner harbour water and the potential for overtopping. Although it's limited, it will certainly be an attribute. So that's why we put it forward. It was something that we wanted to offer, and we've actually offered it to the council. They've not taken it up. We haven't got a response. I accept that Mr. Sillick has been on leave, but no doubt we can deal with it here.
And it's in the proposal you said prior to occupation of plot 35A. The only thing I thought about was whether it should be prior to the commencement of plot 35A. But the rock commitment commenced. And I don't know what your timing is on that, so I don't know how reasonable that is.
Well, the marina will be built before, the wall will be built before the marina is built. It has to be. And the wall would be built before 35A development starts, because it has to be. It would be difficult to use two construction teams. It's one and the same thing. And therefore the development of 35A the wall would be up before first occupation.
Does the council review this condition? I'm not trying to fetter your discretion in relation to the application for plot 35A. That's a different matter, a different application. But in the context of this appeal, do you have any views on this proposed condition?
So I have responded to this in the further written submissions, and suggested that I don't see that the proposed condition would meet the tests of the circular in relation to the outline planning permission. And I appreciate the comments that Mr. Price has made. I'm not pushing back on this condition to be obstinate, but plot 35A is an application, one that's pending consideration, hasn't been determined. It hasn't been brought forward under the planning permission in principle. It's a full planning application. Again, the revetment itself is its own full planning application. It's not been brought forward under the planning permission in principle. I can't see that either development is necessary, you know, in terms of this planning permission in principle, or you know, linked to it in terms of delivery. I would also query, you know, it's very, again, in terms of practicality, being so specific about the revetment and conditioning it might cause trouble in itself. You know, when you're saying that the rock revetment set out in application 2106-095 FUL should be implemented before 35A is occupied or anything else. My question would be, what happens if that permission needs to change? So I appreciate the intention isn't for it to change, but we have the detailed flood risk work that's going to be ongoing. Again, I still haven't seen it. I have no idea where it's going to go. But what happens if one of the mitigation measures is that wall needs to change, and then this is conditioned so specifically to that specification of revetment? So I think it could cause trouble later. I would also say that since we have a full planning application that links to 35A, that anything related to that in terms of the occupation of 35A or the implementation of 35A, it would be appropriate to add this kind of condition to that planning consent in the event that it's granted. I don't see why we wouldn't just do it as part of the full planning application rather than linking it to a planning permission in principle, which isn't directly related to it. I wouldn't have anything else to say on that matter.
I'll give the appellant just a final chance to comment on that.
Yes, I'm rather shocked, really. We heard great length yesterday from the council, their flood risk people and SEPA in relation to this section 42 appeal for this outline planning permission in principle. And it has been said correctly, I think, that this is what's been discussed with SEPA is not relevant to the section 42 planning permission in principle. However, the flood mitigation risks, the overtopping risks, the ability to protect the land from flooding and from any events in the future is relevant, completely relevant to the outline planning permission in principle, which is why we thought, right, well, this condition should appear here. I think that there's going to be an inner harbour revetment wall, whatever. And if there's a minor change to something during construction, that will be something which is non-material. So I don't think Mr. Silly's comments that basically, or it could be dangerous, or what happens if it gets changed. There's going to be a wall, that's all we're saying, and it's going to be built to building warrant approval and engineering approval and to satisfy what would be claimed to be a sea defence, and it could even be a formal sea defence. Not that anybody wants to take up that. I don't know why they don't want to take it up, because it would get rid of any further risks of overtopping. Maybe that would stop the SEPA arguments, which seem to be interminable. So I don't accept what Mr. Sillick is saying, but he won't be surprised about that. And it's up to you, madam, if you want to put it in on the basis of allowing this appeal. We're happy to offer it. And the same way we're happy to offer it, take up Mr. Sillick's offer. Yes, we want to make that a condition of the consent when you do your report prior to the determination to committee. Please do so. We've offered it, and you'll see the effect of it when you see what happens with the correspondence with SEPA over the next few weeks. You'll see the relevance of it, because it gets rid of any concerns about flood risk and overtopping, and that's why we're doing it. Thank you.
Okay, so that was the last question. Any final comments from any party? And I'll start with Mr. Gibbons. Any final comments you want to make?
No, thank you, ma'am.
Okay, the council, any final comments you want to make?
No, thank you, ma'am.
And the appellant, any final comments?
Thank you, ma'am. No, we've nothing further to add.
Okay, well, that brings the session to a close, and just, I know it's been a long one, but thank you all for your contributions. It's pretty complex. So thank you for all your contributions today and for yesterday. I will reflect on some of these points. If I do want any further submissions, the case officer will write out. I may not, I may choose to take the view I've got enough evidence before me. The target date is the 10th of October for my decision to come out, and that will come out from the case officer, and you'll all be notified of that decision when it's issued, either before or on that date. One thing I am reflecting on, and again, the case officer come back, is whether I want to do another site inspection down onto the seawall and look at the temperature revetment, but I'll have a think about that. I think that would probably need to be accompanied, given that there's probably work ongoing. So I would probably invite Mr. Gibbons, who's been involved in the hearing, and the council to attend that if I think I need to do that. But again, that'd be something I just reflect on, and the case officer would write out with this suggested date. And I'm assuming Mr. Freckleton, you're probably the one to coordinate that from the appellant's perspective. But again, I would be in touch. Well, the case officer will be in touch if I think that is something I just want to do, just to just on the basis of evidence I've heard and a lot of discussion. It can be quite useful to go back out on site, just have another look at what's there. So they'll be in touch on that. But just to say thank you, and you're all welcome to go and enjoy the rest of your day.
Thank you.
Thank
Thank you very much.
Thanks.
Thank you, Madam.
Thank you.